Greetings, 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 greetings. It is I, your King, King Clifford Jefferson, ascended of God through the fifth kind of Van Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the 13th English Church of England is none other than Jesus Christ, or the King of Peace. I'm here with another marvelous lecture for my subjects, my heirs, my descendants, all the above. I'm going to use pretty much what we talked about over the past couple of weeks in regards to Frederick Douglass, realizing that, the real ultimate goal in regards to receiving full freedom from bondage is to understanding the status or legal status that the woman was here prior to him acknowledging his paternal and Saxon history. So in lieu of that focus, I'm going to go into a group called is led the co-founder. His name is Naheem, or we know him by Lord Abba. All right. I'm gonna use his platform as a teaching tool to show the people that a lot of people borrow that which was preserved for a specific people. All right. All right. A specific people. All right. Anglo-Saxon is that specific people within the topic in which I'm discussing today. All right. These are the English heirs and descendants. All right. These are the English heirs and descendants, and everybody's are trying to justify their position, their legal status, their existence here, whether it's by religious custom or whether it's by way of incorporation, whether it's by forming a de facto plebiscite or whatever it is. All right. You can't do these things on land that does not belong to you. All right. Legal status denotes to one's legal standing in law. And we know in our eyes that's called a birthright. All right. A birthright. You know what I'm saying? So you must understand one's birthright. Hold that thought. You must understand your birthright. All right. So this one we're gonna do things a little different. We're gonna let the full video play out. Not the full video, but majority of the video from the beginning till we get to Naeem, or brother Lord Abba, in regards to the legal argument, in regards to the misnomer of the term Freeman. All right. Whether you spell it Freedman or Freedmen. It doesn't make a difference how you apply it based off how you identify it without associating the identification in lieu of the name. Because we know names are given to person, place, or things. All right. Names are given to person, place, or thing. We call these names no other than given names a certain name. All right. We know given names are identifying people, and surnames denotes the descendant, ancestry, ascendancy, inheritance, etc. These are proven facts. All right. And we're gonna prove these facts again today. All right. Through the verbiage and the voices of none other than those who are claiming to be the descendants of the one who claimed to be Freeman. And the only legal term where I hear the word Freeman is in the Magna Carta, okay? Preserved for the English heirs and successors. So if you're using this term loosely, I suggest that you should do an in-depth study of the, not just what other people say about the term, but the origin where the term derives from in regards to some legal standing, denote the ones right here on a particular territory, which we call Earth. All right. Very, 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 very important. Once again, I'm going to draw off previous evidence that I brought forth, and I want to pull another one up. This should make sure I got everything covered. Hopefully we don't have any interruptions. I'm having a little internet problem with the TV. Hopefully that don't bother the YouTube or the computer. Give me 1 second, y'all. Bear with me. Yes, that's what I want. All right. Okay, once again, it's going to be a very, very, very good lesson for all those who are viewing it. All right, for all those who are viewing this lesson. And we want to make sure that when you view this lesson, our job is not to defame anybody. All right. We don't want to defame anybody. If anything, we want to clear up the confusion in regards to the misunderstanding that people get when you don't do an in-depth study of what it is that you have or the information that was given to you based off your observation, on what was left for you to observe. All right. So without further ado, let's get started. Promise not to hold you long. I give honor to my queen, Sister Galveston, from the House of Galveston, my moderator, Archbishop Mount from the House of Belmont, as well as all those who are members of the 13th Amendment Church of England, and all those who are on this flight. Like I said, this is a frequency that you have to speed up to. We know frequency is energy, energy is information. Information is direction in which we should all be moving forward to, because we know come information comes freedom. All right. So with that being said, let's get started. Then I want to show
if you're ready for a permanent weight loss solution, consider how weight loss.
what is all right. Freedman University. Everybody see that. This is the university that was created by the co-founder, Brother Naeem Way. He's going to introduce himself in a second. But as you can see, there's Frederick Douglass in the middle. All right. Two other distinguished brothers, all right, Freeman University, all right, and these were the inspirational uh, uh, pioneers for this movement that he called Freeman University, which is an educational tool that all those are of all communities can take part of in lieu of the root of the cause of this group that was created, which is for the main purpose of what we call reparations. All right, reparations, repairing the wrong for people identified as those who were emancipated from slavery. And in this uh, scope of those who were emancipated, they're specifically talking about the five civilized tribes. Okay, they're speaking about the five civilized tribes. Without further ado, let's get started with this marvelous lecture.
Surgery could change your life. At Wood County Hospital, we perform more bariatric surgeries than anyone in Northwest Ohio.
I'm gonna make this introduction, and then we get started with breaking down his topics. What else to do?
All right, family, we're going to get this thing started. I am Naeem Wade, President, CEO, and co-founder of the United Sons and Daughters of Freedman. Today's workshop is for a specific purpose. When we look at our history in this country, we look at the history of white supremacists doing everything within their power to knock us down a peg. We've never had that thing that we can utilize to defeat them. We've never had the tool. Well, I don't want to say we didn't have them. The tools were hidden from us. They were legislated away in some instances. They were judicially constructed and reconstructed in other senses. They were omitted. Black's Law Dictionary, for instance. In today's versions of definitions like status or definitions like freedom, as I'm going to show in my presentation, you're going to see a complete difference in the way these words are being defined. And
okay, he said he's going to break down legal status in regards to the freedmen. All right, according to the freedmen, we know freedmen is a term used for specific people who are emancipated. All right. He's not using the term in regards to a descent name. All right. A name, a patronymic name, or a matronymic name. He's dealing with it from a terminology of regards to those who are emancipated from slavery. All right. Emancipated from slavery. So let's first get an understanding of what legal status means before we move forward. All right. legal status. It embraces all the topics associated with birthright, nationality, and it also associated with a birthright that does not deal with a nationality, but it deals with those who are naturalized based off their ability to be able to be allowed to migrate or immigrate to a specific territory. All right? We must understand that. Let's hope he explains that. Legal status is the status or position held by an entity as determined by law. It includes or entails, that's the word entail, fee simple versus entail, we know that deals with property, as a set of privileges, obligations, powers, or restrictions that a person or thing has as encompassed in or declared by legislation. Legislation, y'all. Law. All right? Not what you want to perceive it to be, but based off law. That encompasses the three types of positions or legal status that one can have. All right? We know that immigration is doing away with one's nationality and birthright. All right? When you migrate from your mother country and you take on a custom that's not your own, then that means that you have no national standards. And that is the position that a United States citizen takes going back to the Articles of Confederation based off the Naturalization Act of 1790 as other than Imre versus Hassan, United States versus Deng Xing, which we're visiting today. We're going to visit those cases today. All right. Then those who and those who migrate does have a nationality. All right. But the nationality is not based off that nation's laws that now occupying the land. We talked about that in my last class deal with acquisition of sovereignty. All right. Which was the spirit of acquisition right of discovery. All right. Which was birthed by right of conquest. We talked about that. All right. We talked about that in my last lecture. So if you haven't watched that one, watch that one before you watch this one. All right. So legal status encompasses birthright, nationality, you know what I'm saying, for those who are national. All right. And Freeman as a surname of a national is not synonymous because the word Freedman is a German word. All right. For the legal status of Germans relative to those who were considered free men from the so-called bonds that they were subject to. All right, so let's move forward.
We believe that this one's a conspiracy. Now, we're not conspiracy theorists, but when has this country, outside of the radical Republicans during Reconstruction, really tried to do anything to help us after that period, or what they call the end of Reconstruction? What we hope to do today is leave people, especially those that are not necessarily familiar with what we teach, with a greater understanding of how we can use Freedman status moving forward. We look at the Fearless Fund, we look at all of these different groups, and all of these different people who are being attacked right now for their quote unquote Black racial programs. And they are being shut down one by one. Corporate Fortune 500 companies, the tech industry, law firms particularly. One of the things that Bloom is doing is, and his group is attacking the law firms so that the law firms will already know that there's absolutely no way, that you're going to be able to defeat, that you're going to be able to use us to defeat them because they've already defeated us. It is a brilliant, brilliant tactic. We believe we have the trump card. We believe that the Supreme Court in its ruling on affirmative action and affirming a position that we at United Sons and Daughters of Freedmen has stood on for the past several years, now have a way to defeat the enemy that's on the right and on the left, because none of them want to see us prepared anyway. They think we're better as the welcome mat to wipe their feet upon as they enter in and out of the house that is called the United States of America. Brother Ali is
Okay, all right. So let's deal with this because his website, Freedom University, which is a social society, all right, which is a platform for you to learn about the freedmen, all right, for you to learn about the freedmen. And some of the icons or the pioneers for freedmen were those such as the one in the middle. It's Frederick Douglass. We know they put him in the middle for a specific reason. All right. We know this gentleman. I don't want to use the word gentleman because that's a status as well. This Anglo-Saxon was subject to a time and era where didn't have the ability to be able to understand the importance of genealogy and ethnicity, and what they're trying to associate the word freeman with. All right. They're trying to associate the word freeman with the genealogy and ethnicity, which can only be derived by what we call a surname. All right, whether it's paternal or maternal, it has to be by what we call a surname, which is very important. All right, which they don't do. They haven't shown the affiliation of the word freeman with the surname in regards to it either being the given name or a name going back to what we call primogeniture, dealing with a birthright in regards to the so-called topic in lieu of reparations. All right, repairing not just you, but you as a member of that nation for the wrong that has done. All right, over here in what we call North America. All right, what we call North America. And we understand that the road for bondage to freedom that was took by Frederick Douglass was now took by identifying himself with a freedman. Now, I'm not talking boastful, but that's just the truth. Now, you notice when we go back to the brothers' demonstration on why they think that their platform or their teachings is a remedy that the people need, and I'm going to hear them out. At the same time, hear them out, I'm going to expose information about what they're saying that they're not telling the people that belongs to another people that they're trying to usurp. All right, that's what I'm going to prove, and you have every right, brother Naeem or brother what's your name what's his name, brother Naeem, Sheikh Bay or Lord Abba. You have every right to not be upset with what's being said, but to bring proof to disqualify what's being said. Because I'm not attacking your character. You know what I'm saying? I love you like a brother. You know what I'm saying? What I am attacking is your misunderstanding of what you present to the people. That's what I'm attacking. Because this is what Frederick Douglass was attacking in regards to the legal status that his people were at the time he went from bondage to freedom. And he clearly showed you what his remedy was for bondage and freedom. Remedy for from bondage to freedom was reading, interpreting what it is that you're reading. All right? Regurgitating and giving that back to those who wrote these books on the interpretation of what it was that he was reading. Because somewhere there was a correlation being made to his identity in regards to what he saw fit in regards to his flight from bondage to freedom. So let's take a view of that because he understood what the law said in regards to bondage and freedom at that time. I hope you're watching, Lord Abba, so you can take some notes, my brother. I love you very dearly. We came into prior conflict as a result of your your um your high horse that you don't want to come off of. You know what I'm saying? You know, you once challenged, you get into the rhetoric of 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 of, of defacing somebody on your platform, you know, in regards to uh 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 defamating them or defaming them, you know what I'm saying, without any valid proof whatsoever to defame anybody whatsoever in regard to their belief, in regards to their stance on who they are. You know what I'm saying? You're in no position to do anything in regards to helping the people that they are in as a result of your ignorance of who and what it is that you claim to be, i.e., a freedman. All right? Yes, a freedman. All right? Let's look at Frederick Douglass as an orator. All right? This is what he went to when he went to the British Isle. All right? Britain and Ireland. All right? This is what he said to the people. All right? This is what he said. Douglas felt Douglas felt that he was lucky to be in the city where he said enslaved people were almost free men compared to those on a plantation. So when you say free man, he didn't say freedman, he said free man. All right? He said free man. You know what I'm saying? And he used it as an adjective, not a noun. He said, we're almost free men. He was a free man at that time, making an argument about those who were almost free men in lieu of those who were subject to those who couldn't be considered free men as a result of the territory where you reside. All right? As a result of the territory where you reside, and these territories were the slave state called the Confederate States, contrast to those which were those ruled by the British monarchs, who were not English monarchs, who preserved the rights of Englishmen as preserved under the Magna Carta. Okay? For those who were of that royal family, all right, through their birthright, based off their nationality. All right? Very important. You can't separate that. It's synonymous. All right. Douglas continued secretly, all right, to teach himself to read or write. This is what we're doing now, y'all. We're teaching ourselves to read and write. What you write depends upon what you read. What you understand is based upon what you read, which results in what you write. All right. Douglas continues secretly to teach himself to read and write. He later often said, knowledge is the pathway from slavery to freedom. As Douglas began to read newspapers, pamphlets, political material, and books of every description, this new rim, that's not a normal word you hear in the days of slavery. That's not a word that you use because we're looking at the words that are being used by this so-called emancipated slave. All right. And he didn't claim to be emancipated based off being assumed to be a free man going back to 5 civilized tribes. We know the 5 civilized tribes is going back to those natives there, which are assumed to be those who are called Mexican. When we know the true Mexicans are the ones misnomer as Almacs, and the original Almacs are those who are of Anglo-Saxon stock. Yes, of Anglo-Saxon stock. Those ancient people who were called freemen, which are no longer are or assumed to be the inhabitants of this territory, which we call North America, which Frederick Douglass clearly proved them wrong. All right. Douglass credited the Columbian orator in an anthology that he discovered at about 12, all right, with clarifying and defining his views on freedom and human rights, all right. First published in 1797, the book is a classroom reader containing essays, speeches, and dialogues to assist students in learning, reading, and grammar. He later learned that his mother had also been illiterate, about which he would later declare. So whatever you should be teaching in regards to Frederick Douglass, in regards to this Freedman University, should be what he's talking about, Brother Naeem. All right? You should be reading what he's reading. I am quite willing and even happy to attribute any love or of letters I possess and for which I have got, despite of prejudices, only to my credit, not to my admitting my Anglo-Saxon paternity. All right? This denotes his legal status, Brother Brother Naeem. His status, his birthright, his nationality is based off Anglo-Saxon paternity, but to the native genius of my sable, unprotected, and uncultivated mother, a woman who belongs to a race whose mental endowment it is at present fashionable to hold in disparagement and contempt, which is the condition that you are under today. All right? Because he understood the importance of a surname. Let's backtrack a little bit. This is just Wikipedia I'm reading. We can go to the book to verify this. Quite so. Birth family. We're talking about legal status, right? We're talking about legal status. Douglas' mother enslaved was an African descent, and his father, who may have been here, her master, apparently of European descent. When you're talking about European descent, you go into the status of that term called Caucasian. All right? Caucasoid. All right? European. All right? And we know that the European here in North America deemed or termed themselves free white person. All right? Having nothing to do with genealogy or ethnicity or nationality or denoting to a particular land of the nationality or genealogy where those people derive from. That was irrelevant to them here as the founding fathers, all right? Douglas' mother enslaved was an African descent, and his mother, who may have been her master, apparently of European descent. In his narrative, Douglas wrote, remember that word, European, because I'm going to blow your mind with that. My father was a white man, all right? White is not a characteristic of a nationality, all right? It's a characteristic of a term being used to identify a group of people where, in regards to that legal status that they throw upon the term in lieu of those people. According to David W. Blight, 2018 biography of Douglas, for the rest of his life, he searched in vain for the name of his true father, paternal father. All right. So he's looking at this much deeper than you're looking at it, brother. Keep it little Abba. No, Abba means father. All right. Abba means father. Abba, father. All right. Douglas' genetic heritage likely also included those that they call freemen, which is composed of the 5 civilized tribes, which were composed of those who were based upon the public trust doctrine, just only occupants on the land that they never owned. So they were only allowed to occupy the land. All right. So what type of reparations can you give the people without even dealing with the point going back to the right of occupancy on the land? All right. Because you have no birthright here. You have no nationality here because the name you chose for those who are going to be going into your school of teachings don't denote to any nationality or any birthright in regards to that going back to a genetic test. All right. Douglas' genetic heritage likely also included American. Douglas said his mother, Harriet Bailey, gave him his name, Frederick Augustine Washington Bailey. And after he escaped to the North in September 1838, he took the surname Douglas, having already dropped his 2 middle names. So he took the surname Douglas. All right. We know Douglas surname we talked about at the family crest of coat of arms, and if I'm not mistaken, Douglas is a Scottish name. All right, Douglas is a Scottish name. We know Douglas is the name that he chose to take as a surname. All right, he chose that name. All right, let's just click here right quick. You understand there was some royalty to the surname. All right. His family would later go to become a part of the African American upper class, continuing to provide leadership and intermarrying with descendants of the African American educationist and political kingmaker, Booker T. Washington. So him and Booker T. Washington are considered part of the African American term for them at that time, were considered part of the upper class, all right, at the time of slavery. All right. He was part of the upper class at the time of slavery in regards to those being enslaved in the Confederate States versus those being on those on Crown land. Because Crown land is intel for those who have a birthright that was left for them based off their descendancy, which Frederick Douglass clearly knew. All right. What is Kingmaker? Kingmaker is a person or group that has a great influence on a royal or political succession without themselves being a viable candidate. They understand they couldn't be a viable candidate because of the political policy that was functioning at that particular time, which was based off slavery, all right? Which involved monetary, religious, military means and influence that success, all right? We must understand that. So we knew Frederick Douglass took the surname Douglas, right? We understand that he associated the word Freeman with the legal status, not the identity of who they were, but the legal status of what they were and in regards to the status they were prior to them being free. All right? Let's stop playing with our brothers and sisters' minds. So he admitted that his ancestry or his descent, his nationality or his birthright was rooted in Anglo-Saxon fraternity. Let's read it from his book. Page 58. He didn't mention Freeman. He's talking about this. His mother was literate as well as he was literate because apparently she knew how to read and he knew how to read because he taught himself how to read. It's important to understand when you say read, it ain't important. It's not important. Reading is the importance is of what you're reading. All right, it's the importance of what it is that you're reading determine if you can read. All right, because a lot of people read stuff and they're reading the notes to something beyond the scope of why a person is supposed to be reading. Because reading is important. Important is to inform you of something. They're already creating a contract by writing something in something that you're reading, and by you reading, you're agreeing to whatever it is that you're reading. All right, so that creates a contract, an obligation. All right, that's edge in both persons' understanding of the agreement in which you're reading. The person who wrote it becomes the grantor, and the person who read it becomes the grantee. All right. Frederick Douglass says, I can therefore fondly and proudly ascribe to her an earnest love of knowledge that a field hand should read, to learn to read. In any slave state, it is remarkable, but the achievement of my mother, considering that the place was very extraordinary. And in view of that fact, I am quite willing and even happy to attribute any love of letters I possess and for which I have got, despite the prejudice, only to much credit, not to my admitted Anglo-Saxon fraternity, but to the native genius of my stable, unprotected, and uncultivated mother, and a woman who belonged to a race whose mental endowment it is at present fashionable to hold in disparagement and contempt. Summoned away to her account with the impassable gulf of slavery between us during her entire illness, my mother died without leaving me a single intimation of who my father was. There was a whisper that my master was my father, yet it was only a whisper. And I cannot say that if I ever gave it any credits. Indeed, I now have reason to think he was not. Nevertheless, the fact remains in all its glaring obviousness that by the laws of slavery, children in all cases are reduced to the condition of their mothers. This arrangement admits of the greatest license to brutal slaveholders and there profligate sons, brothers, relations, and friends, and give to the pleasures of sin the additional attraction of profit. A whole volume might blah, 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 blah. You can get the book and read it for yourself. All right. So it's very important to understand that Frederick Douglass understands that his fraternal origin or his birthright of his nation or nationality, because the surname denotes to your nationality, was rooted in Anglo-Saxon. All right? Anglo-Saxon. Let's go back to the video.
He's going to come on and give a presentation. I'm going to give my presentation. At the end, Sister Antonia, who is also a board member of the United Sons and Daughters of Freedman, and Sister Tati, who does work out in the New England area, particularly in the state of Massachusetts and Connecticut. They are going to come on and give a breakdown and a step-by-step on how to have local engagement with your local municipality so that you too can start this push for local reparations. I'm not one of those people that have to use the word state acts of atonement. And I'm not telling anybody how they should use it. If a state has it within their capacity to repair the freedmen that they are, then they should repair them. And if they repair them in any way, by definition, that is called reparations. So they're going to come on and they're going to give their breakdown. We're going to have a Q&A after it's over with. So we are hoping that you all gain something from this and you're able to take it to where you are and utilize it, because that is the purpose of this workshop, and it will be the purpose of every workshop that we conduct moving forward. So
okay, so this is the objective that the Third Timber English Church is here for as well. All right, we are a religious society. We are a religious society as well as a political society known as a church state. All right, where these things can take place in regards to what he called reparations. You don't have to repair something that was never broken. All right. How you think Frederick Douglass got to the status of where he was by knowing where his rights were? All right. We don't even understand where our rights are. You don't understand where your rights are in regards to the term legal status as a result of the status of your mother. All right. Which Frederick Douglass understood, that's the status of each and every individual presently is the status of our mother, which we call partos sequitur beatrix, which I'm pretty sure you're familiar with that term. All right, let's continue.
Brother Ali, are you ready?
I believe I am. I'm going to present my PowerPoint, right, which is really, just some slides and stuff, but I'm going to actually speak about slides and also the particular topic that I'm going to be speaking on is why we use the term freedmen and the term descendants of freedmen as opposed to descendants of slaves or any other racial classifications, white people or black, whatever, particularly as it relates to the issue of reparations. So let me just, I might turn the camera off while I'm sharing, but just get to the PowerPoint. so you guys can see. All right, so yeah, thank you guys for bearing with us. I really appreciate it, and this is important. Right, so I'm going to be speaking on why freedmen or descendants of freedmen and not Negroes or descendants of slaves, slavery. Why we use these terminologies as opposed to the other ones. So I start off with this. In his famous 1963 Opportune speech, Dr. King invoked the nation's founding 1776 Declaration and its principles of liberty for all men. King stated, "I have a dream that one day this nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident that all men are created equal. The architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence. They were signing a promissory note to which every American was to fall in. This was a promise that all men, yes, black men as well as white men, would be guaranteed the unalienable rights to life, liberty, and the pursuit of happiness."
Okay. We know that is not true because of the Naturalization Act of 1790. Okay. The Naturalization Act of 1790 clearly says that based off the meaning of those who were considered citizens, which those who made up the congressional body deemed to be citizens, were considered free white persons. All right? Free white persons. And the court has deemed that to be what they call Caucasians. All right? Not Anglo-Saxons, Caucasians. All right. So we're going to dig a little deeper into that, but I want him to say a little bit more before I break it down, because I don't want this to be a long class. At the same time, I want you to hear a majority of what the gentleman is saying. All right.
This is what King quoted. Now, many believe that the principles of liberty enshrined in the Declaration of Independence never applied to black people, particularly since the said God-given rights or unalienable rights mentioned were in fact alienated from those classes, blacks, colors, Negroes, etc. Thus, many would take the position that Dr. King was actually in error to suggest it was a promissory note to which black men would fall heir. Was Dr. King wrong here, or did the creed of the Declaration also apply to black men? What does any of that have to do with why those of us who are freedmen conscious describe our families as freedmen and descendants of freedmen as opposed to Negroes, descendants of slaves, or even slavery? Now, to adequately answer these questions, we have to first examine important facts of American history and answer some prerequisite questions. Like, number one, were the ancestors who were enslaved in bondage against their will actually members of the human family, or were they simply the Negro beast of burden that Europeans supposedly were? Number two, were the enslaved ancestors not men and women endowed by their creator with said unalienable rights, or were they subject to alienation rights by colonial and state actors obsessed with oppression? Is there any evidence, number three, is there any evidence to support the idea that the Declaration's principles of equality and liberty apply to black men as well as white men, as Dr. King stated? Number four, was slavery legal, or was it an unconstitutional institution that was tolerated via a series of compromises between the original northern and southern states? And if it was unconstitutional, was slavery in contradiction to and in violation of the constitutional laws of England?
Hold on. Did he just say England? What does that got to do with African Americans? All right. What that got to do with Freeman? All right. If you're going to use the word Freeman associated with England, then you have to associate that with the Magna Carta and those who are heirs to that legislation as deemed by the Magna Carta, and that's going back to John, son of Henry II, son of Godfrey, the fifth kind of man Jew. You can't make that relation based off a term that you choose to identify your organization with that you establish here and that you're talking about right now. Okay? We understand that that was not Frederick Douglass' intentions. Even though he had to use what at his disposal, he understood that the origin of the foundation of the rights and remedies that were reserved for all those from bondage to freedom was rooted in the paternal message that comes from understanding primogeniture, birthright. Okay, he understood that. All right, just because you cut and pasted and put something on the screen for people to make a connection to, they're still going to be dumbfounded. All right, because you're using England, but not English subjects or English heirs who have English nationality, have an English custom, have an English tradition. Freeman can't associate themselves with that. Those who are English heirs can associate themselves with the term freeman because it's a term denoting to people who are free, who don't have to be emancipated, because the Magna Carta had nothing to do with people being emancipated from slavery. It's just a preservation of the right in case they were being enslaved, which is Dred Scott so illustrious put in that case. All right, let's continue.
Founding declaration and a violation of the right to the writ of habeas corpus. Number 5.
Stop. Habeas corpus is a prerogative writ, which is a writ belonging to the king as a part of his jure regalia. That's not a writ that everybody can use. All right. When you use that writ, it's at the discretion of the judiciary to grant such a writ. All right. For a subject, it's a right. It's called a petition of right. All right. For all those who need clarity on that, see United States versus O'Keefe as well as Chisholm versus Georgia. All right. It clearly tell you that.
What was Lincoln quoted as saying in regards to the freedmen and their involvement in the Civil War? 6. Were the promises and commitments of Reconstruction made to the slave class or to the class of freedmen? I have 2 more questions, but I'm going to leave those 2 questions for Brother Naheem to answer. The last 2 questions are number 7. Are today's living freedmen descendants also members of the freedmen class? And if so, how do we know? Does Roman law influence American jurisprudence? That's number 7. It's a 2-part question. And number 8, what did the Supreme Court of the United States, the justices, recently have to say in regards to the historical and legal use of the term freedman? Now, in order to...
Okay, so Naeem is going to answer questions 6, 7, and 8. All right? In regards to how the Romans, all right, termed the word freeman. First of all, we're not in Rome. All right. Roman law that and how you apply it is not even the foundation of what American law was rooted in. American law is rooted in English common law, Smith versus Alabama. Now, yeah, you might see the word freeman denoting to the Romans' interpretation was a freeman, but it had nothing to do with the laws governing freemen over here in North America in regards to the emancipation of freemen. All right? There's no correlation there. The people who are viewing your channel don't understand that. So automatically you've been in time and space. You got these people in 2023 going all the way back to Rome. All right, ain't got not one piece of shredded instrument to prove or validate any presumption at law to validate the connection that freemen have to Rome right now. Not one shredded proof. I haven't seen one yet. Let's go.
Properly frame the answers. I like to preface them by using the freedmen of the so-called 5 civilized tribes as an example, particularly because they never stopped using the term freedmen in reference to their families. So with them, we have those known as Cherokee Freedmen, Chickasaw Freedmen, Choctaw Freedmen, Creek Freedmen, and Seminole Freedmen. These names serve as their ethnic identifiers.
So these are their surnames. Cherokee, Choctaw, Seminole, these are their surnames that denotes their ethnicity. All right? So if that's the case, then you don't have no birthright here in North America, because based off the right of discovery doctrine under Johnson versus McIntosh and the public trust doctrine as rooted in Martin versus Waddell, the Native American Indians, i.e. the 5 Seminole tribes, were nothing but more than mere occupants on the land. Okay, so you don't have a birthright here. That means that only makes you a migrant or an immigrant who migrated here. I'm only showing you what you're telling me. All right, let's see. Let's get some proof. Let's get some proof. Freeman. Freedman. A freedman or a free woman is a formerly enslaved person who has been released from slavery, usually by legal means. Historically, slaves were freed by manumission, granted freedom by their owners, emancipation, granted freedom as a part of a large group of self-purchased. A fugitive slave is a person who escaped enslavement by fleeing. So that means they're subject to fugitive slave law. All right. Then they're associated with the term freeman with ancient Rome, all right, which he's making a reference to. But you can't use English law or English decisions to justify the term freeman. All right? You can't use it unless you associate the term freeman with a group of beings being termed freemen without even including slavery at that time in regards to the Magna Carta, right? Who are now members of a university, all right? They're members of a church state, a polity, a government, a nation, all right? A public entity. You're not. Ancient Rome. All right? So that means that if you're associating freeman and you're using ancient Rome to validate it, then that means that the word freeman, as you use it, should associate yourself with a Roman, which means that you are a Roman. All right? Or am I wrong? I could be wrong. That's left for us to discuss when you get the courage to come on, because like I said, I reached out to you plenty of times, but to the end result, nothing. But yet you're still up to your old schemes. Let's get it. Hold on for 1 second. All right. Freeman. All right. Is also found in, I'm sorry. All right. Is also found in Scandinavia. It's also found in Arabian and North African slavery. It's also found in the United States. All right. There's also that's where you see it. All right. And one paramount case that deals with slavery in the United States and those being emancipated from slavery in the United States is the Dred Scott case. All right. That's the main case in regards to the legal status of those now being called freemen from that status called enslavement. All right. And we know that Frederick Douglass was at odds with Chief Justice Taney's declaration of the legal status of people at that particular time. He said they were Anglo-Saxon. All right. He said they were Anglo-Saxon versus those who were trying to be Anglo-Saxon. All right. We must understand that. Let's look at this word freeman. Family crest and coats of arms. Freedman. The Freedman surname evolved from the popular German personal name Frederick. All right. Early origins of the Freedman family, the surname Freedman was first found in East Prussia or Silesia. It later became more prominent as a numerous branch of the same house acquired distant estates, some of which were located in other countries. Through the acquisition of these estates, as well as their important contribution to society, the family successfully elevated their social status. You know what acquisition means, right? Acquisition means the conveyance, the transfer of territory under that who claimed to be sovereign through what we call either by 5 ways: accession, loan, exposure. What we do exposure by a specific person or king. What else? Conquest, secession, and prescription. All right. These are all resulted from acquisition of sovereignty. We know acquisition of sovereignty is a result of one claiming to be the sovereign on the land, which is called prescription of sovereignty. All right. Under the prescription of sovereignty, without it being attested, which is the case in point, that people are making claims and interests and want remedies for atrocities committed upon them when no such right is deemed necessary for you in regards to you not knowing who you were. All right. You living off somebody else's virtue, just like the colonists are living off somebody else's virtue. All right. We're going to see that today as case law states. All right. Let's get to it.
Distinguishes them from those of us commonly known as African Americans, i.e., the 13th Amendment freedmen. The terms freedman or freedmen also denotes an acquired status, usually by some lawful means. What's important to also note about the Indian freedmen families is that when speaking specifically of their ancestry, they use terms such as freedmen descendants, freedmen and their descendants, or descendants of freedmen. And although their emancipated ancestors were formerly enslaved, just as I was, what we don't see the Indian freedmen do is refer to themselves as descendants of slaves or descendants of slavery, and with good reason. In a 2021 article published by High Country News entitled 7 Questions.
These are their sources. All right. These are their sources that they're using to validate the freedmen or the term freedmen as a proper identity for those who are emancipated. And reparations is the right for those who use this terminology as created under freedmen for those who claim to be of an ethnology or genealogy of those who descended from the 5 civilized tribes. Okay, and we know case law clearly says that they were mere occupants on the land. All right, we're going to prove it.
About freedmen answer, these points were expounded on by the author. For example, the article's opening paragraph states that Marilyn Vann began her groundbreaking position as the first Cherokee citizen of freedman status to hold a position within the Cherokee Nation government.
Part 2 secretary being trimmed. All right. That's the status of the mom or the parts of the mother. holding a position in the government. That was not how we did it in England. All right, not to talk bad about the queen or the woman, because she had her obligation by keeping the household in order, keeping the children, keeping the functions of the house, making sure that the mental state of all those in the house was at that standard of that royal base that they had to uphold at all times. All right, let's look at the evidence.
This speaks to the fact that this woman is a Cherokee citizen of Freedman ancestry, and the inherited status also holds position in the government of the Cherokee Nation. So not only is she of Freedman ancestry, but she also has the inherited status of Freedman, and she is a citizen and holds position in the Cherokee Nation's government. This is important for those who have made themselves believe that citizenship in a nation somehow abolishes the status of freedom. The article continues, quote, when slavery ended in the 5 tribes after the formerly enslaved people became known as freedmen. They spoke tribal languages, ate tribal food, and lived in the manner of the tribes of their former owners. By any cultural metric, they were Choctaw, Chickasaw, Cherokee, Muskogee, and Seminole people. The ethnic identities of the descendants of the freedmen are distinct from both African Americans and tribal members generally.
They're separate. They're different. That's what he said. They ain't the same. Not one shred of proof to say they ain't the same. All right? Not one shred of evidence. This is their evidence that they're using.
Anyone who has a freedman ancestor is a freedman descendant. Speaking of ancestry, it's the terms they use. Whether their ancestor appears on the by blood or the freedman rolls, it remains an ethnic and ancestral identity. But freedman status is an official designation, meaning that the tribe views you as part of a designated class and limits or extends your rights accordingly, end quote. And finally, the article states, quote, the tribes promised to enroll freedmen, but didn't. When slavery ended in the United States, it didn't end with them. By fighting for the Confederacy in the United States, the 5 tribes had forfeited the rights set out in earlier treaties with the United States. So, in 1866, after the Civil War ended, they signed new treaties with the U.S. government. The new treaties directed them to end slavery and extend citizenship rights to freedmen. But the tribes delayed for years, leaving freedmen with no country. At the time, they were not recognized as either tribal or American citizens. Eventually, some of the 5 tribes did enroll the freedmen, only to disenroll them later. End quote. Now, fortunately or unfortunately, members or citizens of the 5 tribes, including freedmen, were not U.S. citizens and did not receive U.S. citizenship until the 1901 5 Tribes Citizenship Act was passed. Regardless of any imposed racial misnomers such as Negro or anything like that, which appears in the 1866 treaty, in their quest for justice, the idea of using such delineating identifications as Chickasaw freedmen or Choctaw freedmen, which is inclusive of the freedman status, is to ensure that their particular class of freedmen, in contradistinction to the American freedmen, are recognized as the proper beneficiaries of the specific remedy that they're seeking. This makes perfect sense. So, what the author has expressed about the freedmen of the so-called 5 civilized tribes is that the names such as Choctaw, Chickasaw, Freeman, etc., functions as their ethnic names, while a term like freedmen descendants is used to denote their ancestry. And then the standalone word freedman remains the designation of a heritable official status. I think it's important also to point out that the term free slave is in fact an oxymoronic term designed to psychologically damage the freedmen by implying that regardless of manumission, they are slaves in perpetuity. The term free slave should be removed from the American lexicon because the proper and respected term is free men. Now, the first requisite question I asked was were their ancestors were held in bondage against their will actually members of the Union family, or were they simply the Negro beasts of burden that Europeans supposed they were? Well,
Stop. Okay, first of all, no proof whatsoever. You're reading the scripture going back to the creation, okay? Creatures on the land. God said, let earth. I mean, what kind of reference is that when you know the person who put that there was a monarch of the King of England, which was a Scottish king. And those who were Scottish kings were practicing slavery at that time. Dred Scott said that Great Britain brought in slavery and it was incorporated inside of the colonies. All right. And it was emphatically part of the state legislature, Section 9, Article 1. All right. And it was regulated through Section 3 of Article 4 of the Constitution established in the Dred Scott case, which no reference to that had been made to that. They took the change off the slavery off the chain and mentally kept you in chain or mental slavery based off your perception of freedman. You're still a slave because we know that freedman, as you deem a legal status, has to deal with a nationality, a birthright. If it don't include a birthright, i.e. a nationality, that means that the only thing you can be is a foreigner or a migrant who immigrated here. And we know that under the Dred Scott case, under Section 9 of Article 1 of the Constitution, that slavery was emphatically a part of the legislature through the use of what we call migration. All right? Migration. I'm not picking on you. These are just facts that you have not come to terms with. All right? You have not come to terms with. Let's get another validation. Since you're saying that the Cherokee and the African American are not the same, those are misnomers: Cherokee, African American, Negro, etc. Frederick Douglass understood that because you got him as one of the pioneers on your platform for the Freedman University. Okay, you got him there. Let's check this out. Let's go to the public trust doctrine. Martin versus Waddell. This is the public trust doctrine, all right? The land in controversy, because you got to be on the land. Freedmen who got free or emancipated from slavery on the land had to be on the land. What land is in question, all right? And who's on that land is also in question. And by what authority on that land do they have the right to be there is also in question, all right? The land in controversy is within the boundaries of the charters and the territories which now forms the state of New Jersey, which we know represents the crown. The territory and the grant by succeeding conveyances became vested in the proprietors of East Jersey, who conveyed the premises in controversy to the defendants in error. The properties by the term of the grant to them were originally invested with all the rights of government and property which were conferred by Duke of York afterward in 1702. The properties surrendered to the crown. All power of the government retained to their rights and property rights. So we're talking about crown property. When you're dealing with the slavery and regulation of slavery, you're dealing with those laws would allow that to exist, where it deals with the laws of acquisition of sovereignty, which denotes to succession. All right. We know succession by ceded territory. We know that the ceded territory that belongs to us as heirs intel came by way of de facto monarch sitting on the ground. And for us to understand that, you must know the history of North America, dealing with the jurisdictions that Spain and French monarch had over here prior to the colonies getting their authority from the British colonies, who got their territories through what we call treaties. All right, because they're talking about treaties. All right. We know that the Treaty of 1763 was the treaty of the territories that belonged to France and Spain succeeded to the King of England, now known as Great Britain, by what we call the Union of the Crowns. All right, that's the uniting of what we call the Crowns, which is the government, Scotland government with the English government, and we know English government over here is paramount. Why? Let's see. the right of the King of Great Britain to make this grant to the Duke of York with all its prerogatives. We know prerogatives is those writs you were talking about. Writ of habeas corpus, bring forth the body. All right. We know that under the Fifth Amendment, you have the right to not be brought forth to what they call it, give testament upon yourself. All right, right to remain silent, as well as the right to not be deprived of life, liberty, or property, which is unconstitutional. But unconstitutional for who? This right was not a part of the 14th Amendment application for the emancipation of the so-called freedmen. All right, this is not a right that you have. This was one of the encumbrances, one of the exclusions in regards to your emancipation. All right, the English possession, it didn't say freedmen. So you can't use case law referring to English who are freedmen as mentioned in the Magna Carta, which you're trying to make a reference to if you're using case law. All right, case law don't make reference to freedmen in regards to how you see the term freedman, which goes back to Rome, because Rome invaded England. All right, English possession in America were not claimed by right of conquest, but by right of discovery. You hear that? We know when you're dealing with right of discovery, then you go into the Johnson versus McIntosh. All right, right of discovery is governed by the Johnson versus McIntosh. All right. The country granted by Charles II to Duke of York was held by the king in his public regal character as a representative of the nation and trust for them. The discoveries made by persons acting under the authority of the government were for the benefit of the nation and the crown, according to the principles of the British Constitution, which was upholding or preserving the rights of the public domain, i.e. the public trust, i.e. the federal land, which actually belonged to the crown because it was called crown land, was the proper organ to dispose of the public domain as cited in Johnson versus McIntosh. We see that also quoted in what? Dred Scott versus Sanford. All right. The dominion and property and navigation of waters and the land under them being held by the king as a public trust, the grant to any individual of an exclusive fishery, any portion of it is so much to take it from the common fund entrusted to his care for the common benefit. In such cases, whatever does not pass by the grant remains in the crown for the benefit and the advantages of the whole community. Let's go to 14. Public trust doctrine, y'all. Martin versus Waddell. Check it out. Martin versus Waddell, public trust doctrine. The principles here stated by Hale as to the public common of Piscary belong to the common people of England. It didn't say freemen. It is not a question by any English writer upon that subject. The point upon which different opinions have been expressed is whether since the Magna Carta, either the king or any particular subject can gain a propriety exclusive of the common liberty. For undoubtedly, rights of fishery exclusive of the common liberty are at this day held and enjoyed by private individuals under ancient grants. All right? But this existence of a doubt as to the right of the king to make such a grant after the Magna Carta would of itself show how fixed has been the policy of that government on the subject for the last 600 years, and how carefully it has preserved this common right for the benefit of the public. And therefore, there is nothing in the charter before us indicating that a different and opposite line of policy, but does designed to be adopted in that colony. On that contrary, after enumerating in the clause herein before quoted, some of the prerogative rights annexed to the crown, but not all of them, general words are used conveying all estate rights, title, interests, benefits, advantages, claims, and demands of the king, and in the lands and premises before granted. The estates and rights of the king passed to the duke in the same condition in which they had been held by the crown, and upon the same trust. Whatever was held by the king as a prerogative right passes to the duke in the same character, and if the word shows the appropriate word to pass lands covered with the navigational waters, as contended for one part of the defendant in error, it is associated in the letter pattern with the other royalties and conveyed as such. No words are used for the purpose of separating them from the jure regalia and converting them into a private property to be held and enjoyed by the duke apart from any independent or political character which he was clothed by the same instrument. So remember, people change, but positions don't. All right? People change, but positions don't. All right? It says this opinion is confirmed by referring to similar grants for other tracts of countries upon this continent, made about the same period of time. Various other charges for large territories on the Atlantic coast were granted by different monarchs of the Stuart dynasty to different persons for the purpose of settlement and colonization. It said nothing about ownership. It said nothing about ownership. All right? This is the public trust doctrine. All right? The public trust doctrine in regards to people making claims on something that not belongs to them, whether it's real property or personal property, inalienable, whether it's what we call it, what's the other term? I forgot the other term, but as we can see here, that people are making claims to a right and benefit and protection that law that are not reserved for them. All right? It's not reserved for you. We must understand that. All right? Let's see what Frederick Douglass said. All right? What does Frederick Douglass say about this? Because you got him on your platform. So you should know this. Or am I wrong? I'm able to be to stand corrected. Because this is Douglas' story on the retelling of the Anglo-Saxon America, who rightfully had the right to be termed Anglo-Saxon. All right? Before we read that, let's go here. Oswald versus United States. This is no different than this is all dealing with citizenship here in North America. All right. This deals with legal status here in North America. We know legal status either deal with birthright, nationality. If it ain't birthright, nationality, then that means you deal with immigration, migrant, i.e. slave, as stated by Dred Scott. Only 3 of them. So you got to take your pick, brother Lord Albert. You have to take your pick, right? And Freedman is not one of the classifications. All right. We already see Frederick Douglass choice. It was Anglo-Saxon fraternity. All right. All right. And we talk about Freedman. The topic is Freedman, y'all. Oswald versus United States, 1922. The question then is, who are comprehended with the phrase free white person? All right. Freedman versus free white person. That's the question. Freedman versus free white person. Who has the more or the most superior legal standing in law? Free man or free white person. All right. Based off your understanding based off their understanding and based off Frederick Douglass' understanding, which is our understanding. Me and Frederick Douglass' understanding is on the same frequency, right? But our understanding, me and you, Lord Abba, and the Freedom University is not on the same frequency. Why? Because of what you teach. All right? This has to be brought to light to the people, as well as all the platforms. Because you got how many members? 100 and wait a minute. 10,007 10.7 thousand subscribers. This is how many members you got following you. So as a lack of understanding of all those followers, because those who listen to the piper follow what the piper said. All right, and that leads them to their demise. All right. All right. Is you really taking them to freedom, or are you leading them to their demise? That's the question. All right, that I pose to you. You have time to change your mind. All right. Let's see what Oswald versus United States says. All right. The question then is who are comprehended within the phrase free white person? Because you said you're a free man. All right. So you should be included in that free white person because you stated that, or the gentleman with you stated that in regards to the meaning and interpretation of the Constitution of 1790. All right. Which I'm telling you was a slave instrument. A slave, an instrument denoted to slavery and the regulation of slavery, as stated by Section 9, Article 1, and Section 3, Article 4. All right. The question then is who are comprehended within the phrase free white person? Undoubtedly, the word free was originally used in the recognition of the fact that slavery then existed and that some white persons occupied that status. You hear that? Undoubtedly, the word free was originally used in recognition of the fact that slavery didn't exist and that some white person occupied that status. So if the white person occupied the status as free, then the only person that those who were enslaved occupied was that of the slave. The word, however, has long since ceased to have an impractical significance and may now be disregarded. All right? We have been furnished with elaborate briefs in which the meaning of words white persons is discussed. And we're talking about the Naturalization Act, all right? Talking about the Naturalization Act. With the ability and at length, both from the standpoint of judicial decisions, not cut and paste stuff that you cutting and pasting to teach the people, but from case law, judicial decisions, with the ability and that lens both from the standpoint of judicial decisions and from that of the science of ethnology. All right? Not because you want to use the word to fit whatever you want it to fit. All right? And based off ethnology. All right? It does not seem to us necessary, however, to follow counsel in their extensive research in this field. It is sufficient to note the fact that these decisions are in substance to the effect that the words import a racial and not an individual test, and with this conclusion, forfeited as it by reason and authority, we entirely agree. Manifest destiny, the test afforded by the mere color of skin of each individual is impractical, as that differs greatly among persons of the same race, even among Anglo-Saxons. All right, ranging by imperceptible gradation from the fair-blinded to the sportsy brunette, the latter being darker than many of the lighter-hued persons of the brown or yellow race. Hence, to adopt the color test alone will result in a confused overlapping of races and gradual merging of one into the other without any practical line of separation. This is where Frederick Douglass put his foot down. Frederick Douglass put his foot down. Let's see where he put his foot down. Douglass' trip to Britain left him with the impression. Douglass' trip to Britain, he went to Britain as a result of his book, The Narrative of Slavery. All right? He went to Britain to be emancipated by slavery by Britons who emancipated them by paying that tax. Yeah, they paid that tax for him to free this man as a result of his influence on them. Douglas' trip to Britain left him with the impression that America was a web of narratives constantly being retold. In his farewell to the British people, Douglas said, "The fact is, the whole system, the entire network of American society is one great farce from beginning to end." Later, it is the same speech he said, "We are a nation of inconsistency, completely made up of inconsistency," giving Douglas' sense of America as a composite of stories. It is unsurprising that upon his return to the United States, imbued with a new sense of agency, he will become one of the nation's most famous and controversial storytellers as editors of the North Star. So what story did Frederick Douglass tell? All right. What story did he tell? Let's see. North Star, September 16, 1849. We deem it a settled point that the destiny of the colored man is bound up that of the white people of this country. We just read that in Oswald versus United States as a result of the color of skin. All right? And we know that the Naturalization Act is based off the color of skin. It had nothing to do with any genealogy or ethnicity, which either can be maternal or maternal. And we know Frederick Douglass chose the paternal side because he understood the paternal side, because he understood the maternal side of it, i.e. his mother was at the state of Part 2 Secretary of Trim, which is present in this very legislation that we have today. All right? It's stated here. But the destiny of the latter, what it may be, what it may. They talking about that of the white people, because that's the latter. Douglas capitalized on the Anglo-Saxonism to show that the true heirs to the Saxon legacy as the conquered people, going back to the laws of what we call right of conquest, and we know that goes back to who? Henry VIII. The Saxon legacy as the conquered people were not only Mexican, as the example above, but also black. In Douglas' view, blacks had even more of a claim of Anglo-Saxon cultural heritage than Mexicans did, given their common enslavement. For Douglas, black Americans could understand Anglo-Saxon England as a point of origin by invoking medieval English history and challenging white members of his audience to think of themselves as oppressive Normans rather than Anglo-Saxon. You hear that, brother Naeem? You hear that? Douglas participated in vaulting historical Saxons while he called for an end to the Anglo-Saxon sense of racial superiority. And the model of the Anglo-Saxon legacy of freedom could be more widely acceptable. In American England, Christopher Hanlon's right tapping the transatlantic genealogy that had circulated through his national culture since at least 1850, Douglas assumed his white Northeastern audience to regard themselves as descendants of those Saxon serfs and plumbed that habit of identification for its further implication. All right? So we all can clearly see Frederick Douglass stand on his identity as an Anglo-Saxon, going back to that ancient race who inhabited this territory, which we call North America, contrast to those who are trying to be that ancient race who inhabited North America. How do we know that? Let's see the right of discovery doctrine. Let's see that. Johnson versus McIntyre. I see this. You see this, right, brother? What's your name? Lord Abba, Lord Father Abba. Our late acquisition from Spain are of the same character, and the negotiations which preceded those acquisitions recognize and elucidate the principles which had been received as the foundation of all European titles in America. All right. The United States then has unequivocally, let me make sure I got that word right. The United States then has unequivocally acceded to that great and broad rule by which its civilized inhabitants now hold this country. They hold and assert in themselves the title by which it was acquired. They maintained, as all others have maintained, that discovery gave the exclusive right to extinguish the Indian title of occupancy either by purchase or by conquest, and gave also a right to such a degree of sovereignty as to the circumstances of the people would allow them to exercise. All right, so it includes the civilized tribe. The power now possessed by the government of the United States to grant lands resided while we were colonies in the crown or its grantees, i.e., the civilized tribe. The validity of the title given by either has never been questioned in our courts. It has been exercised uniformly over territory in possession of the Indians. The existence of this power must negative the existence of any right which may conflict with the control of it. An absolute title to land cannot exist at the same time in different persons or in different governments. An absolute must be an exclusive title, or at least a title which excludes all other not compatible with it. This is called elonio. Not aboriginal, not fee simple, not fee indefeasible, not fee life estate. All right, all these are legal tangers that are what we call subject to reversion and remandment as a result of them being subject to what we call being intel. All right, being that the state is intel, they're subject to reversion and remandment as a result of what we call prescription. All right, as a result of prescription. So it says an absolute must be an exclusive title, or at least a title which excludes all others not compatible with it. So that means there must be a quiet title. All right, free from all encompasses. Hell, the United States ain't got that type of title. All right, not even the Native Americans got that type of title. Why? If that was the case, then you wouldn't have what they call the treaties. All right, in regards to what we call the domestic slave trade, which have removed the natives, the indigenous people, or the aboriginal people from one territory to another. All right, if you had that much power, then that resulted from what we call acquisition of sovereignty by way of what we call right of conquest or what we call right of secession. And these are not dealing with right of conquest; they're dealing with right of secession. They were agreed upon by both parties. All right, unlawfully. Why? Let's read on. All our institutions recognize the absolute title of the crown, subject only to the Indian's right of occupancy, and recognize the absolute title of the crown to extinguish that right. Did you hear that, Lord Apple? Did you hear that? This is incompatible with an absolute and complete title in the Indians. We will not enter into the controversies whether agriculturists, merchants, and manufacturers have a right on the abstract principles to expel hunters from the territories they possess or to contract their limits. Conquest gives a title which the courts of the conqueror cannot deny. Whatever the private and speculative opinions of individuals may be, respecting the original justice of the claims which has been successfully asserted, the British government, which was then our government and whose right had passed to the United States, asserted titles to all the land occupied by Indians within the chartered limits of the British colony. It asserted also a limited sovereignty, acquisition sovereignty over them, and the exclusive right of extinguishing the title which occupancy gave to them. These claims have been maintained and established as far west as the river Mississippi by the sword. All right? By the sword, y'all. You hear that? Let's go even further. Frequently, in bloody wars in which the whites were not always the aggressor, unavoidably ensued European policies, numbers, and skill prevailed. As the white population advanced, that of the Indians necessarily receded. The country in the immediate neighborhood of the agriculturists became unfit for them. The game fled into a thicker and more unbroken forest, and the Indians followed. The soil to which the crown originally claimed title, being no longer occupied by its ancient inhabitants, was parceled out according to the will of the sovereign power and taken possession by persons who claim immediately from the crown or immediately through its grantees or deputies, i.e. the Native Americans. All right? So that's your window of opportunity, Loaba. How we know that? Let's go a little further. After stating that these controversies between the several states and the United States have been compromised, the court thought it necessary to notice the Indian titles, which, although entitled to the respect of all courts until it to be legitimately extinguished, was declared not to be such as to be absolutely repugnant to the seizures and fee, i.e. possessors and fee, on that part of the state. When you know fee, we're talking about fee simple, right? We're going to come back in. Let's go back to Lord Apple.
The obvious answer is that they were not equal beasts, but were in fact members of the human family, held in bondage as chattel against their will and forced into involuntary servitude. Those of us who subscribe to the Judeo-Christian concept of creation, Genesis chapter 1, verses 26 to 27 is clear about who was created in the image and after the likeness of God when it states, and God said, let us make man in our image, after our likeness, and let them have dominion over the fish of the sea, over the fowl of the air, and over the cattle, and over all of the earth, and over every creeping thing that creeps upon the earth. I just want to quickly point out that what we know as cattle are beasts or animals that walk on all fours, and in certain instances used as beasts of burden. However, when it comes to the comparison of the inhabitants and the descendants of Africa to cattle, there is no history of walking on all fours as others were known to do. Now, Africa and its descendants have many problems, but walking on all fours is not one of them. Genesis continues. So God created man in his own.
I don't know why he even brought that point up. All right. That has nothing to do with the topic whatsoever about people walking on all fours. All right. Nothing whatsoever.
Own image. In the image of God created he him, male and female created he them. So in this sense, man is inclusive of male and female, i.e. humanity. That leads right into the second question. Were the enslaved ancestors not men and women endowed by their creator who said unalienable rights? Were they subject to alienation rights by colonial state actors obsessed with oppression? To address the issue,
how could you fit this story in that timeline? How could you fit the story of God in the timeline dealing with the time of the Freeman? It's two different time periods. The laws that were created by God is not physical law. All right? God wasn't even no physical man at that particular time to even make a correlation to the physical man at the time was being enslaved, unless that God we talk about in this King James was a slave holder. And we know, according to the history of King James, the real God was a slave holder.
said God given unalienable rights. I go back to Genesis chapter 1, where verse 28 reads, and God blessed them and said unto them, be fruitful and multiply.
Hi everyone, Mark Barton here from City Promise. On December 14th, 2012.
Multiply and replenish the earth and subdue it, and have dominion over the fish of the sea, over the fowl of the air, and over every living thing that moves on the earth. According to the Judeo-Christian text, God created man in his image and likeness and gave or blessed man with the right to freely live life and to multiply and to replenish the earth. Man was blessed with the right by God to subdue the earth, to reign over the animals of the planet. Man again means humanity, and the so-called Negro is a member of humanity. Now, in his dissent during the Dred Scott case, Justice Curtis cited the 1838 North Carolina Supreme Court case, State versus Manuel. In said case, Judge Gaston made this particular claim about the state of North Carolina. Quote, all free persons born within the state are born citizens of the state. The Constitution extended the elected franchise that every free man had arrived at the age of 21 and paid a public tax, and it is a matter of universal notoriety that under it, free persons, without regard to color, claim and exercise the franchise until it was taken from free men of color a few years since by our amended Constitution.
Scott. Okay, so he's showing you Dred Scott. All right, we know Dred Scott was a slave who ran away from his slave master, or was part. So we know Dred Scott was a slave who was considered free because he ran to a free state. But Chief Justice Taney claimed that presumption was wrong. All right. And we know that Frederick Douglass had a problem with the Dred Scott case in regards of Chief Taney's position on the status of people with misnombered as Negro, Black, colored, Ethiopian, as well as freemen. All right. These terms will not suffice. They will not suffice. Why? Because we understand that as Frederick Douglass said, that they're only doing to what we did to them. All right, they're only doing exactly what we did to them. Chief Justice Taney said that. He understood his position as a slaveholder. We understand that the Constitution regulated slavery, instituted slavery, because we know Dred Scott case says that slavery was instituted and incorporated in the colony and brought over by Great Britain. All right. Now, why are you showing this, Lord Abba? Why are you not showing this, whatever your name is, my brother? Why are you not showing that? Because I'm going to let you speak a little bit more and hopefully you'll show it. If not, then we'll do it as I have already done on this platform. In regards to the people who are viewing this can see that these platforms are actually workers of iniquity. All right. They want to position and power of the crown, and you have no such power. All right. We know the crown is a natural person, do corporation. So you're not that it. You're not it. I am. I'm that person. I'm that entity. I'm that personification. I'm that incarnation. So no matter who you incorporate in by way of sitting down and filing something with the county clerk, you'll never get to the position of being the image of Christ. All right? You'll never be in that position of being that one to be able to take that property which has gone bona vacatina as a result of interstate. All right. No heirs being there on that ancient land, which is called crown land. All right. We understand that. You need to understand that. All right. Let me go a little bit further, dig their hole.
So here we see some confirmation from Dr. King's words, where even in the southern state of North Carolina, all free men born there, regardless of color, were heir to the elected franchise until it was maliciously taken from those of African descent by way of amending that state's constitution, a violation of the principles enshrined in the founding declaration. So the next question is there any evidence to support the idea that the Declaration's principles of equality and liberty apply to Black men as well as white men, as Dr. King stated? James Otis, an American lawyer, political activist, politician, an author writing for the Smithsonian called The Colony's Most Galvanizing Patriot, published in 1764 what was called The Rights of the British Colonies Asserted and Proved. In his publication, Otis asserted that Blacks had inalienable rights, and he favored extending the freedoms of life, liberty, and property to them. The idea of racial equality also permeates his publication, in which he states, quote, "The colonists are by the law of nature free born, as indeed all men are, white or black.
Okay. This is what the colonists said, that all men are freeborn, black or white, based off the status of being black or white. And we know with black is the result of your emancipation. We know James Otis was a colonist who took on the identity of the Anglo-Saxon, which is contrary to what Frederick Douglass said they were. They were the ones who invaded England under the Norman conquest, which is still going on today here in North America. All right, because the laws that apply at the time of the Norman conquest apply over in North America, because those kings who were living at the time of the pre-Norman conquest were over here in North America by way of what we call legislative statute. All right, I'm gonna show you. All right, I'm going to show you that, Lord Apple, you don't have a clue about what you're talking about in regards to what it is that you're teaching in lieu of repairing the harm that was done to the people of this ancient people that we're talking about today, which Frederick Douglass said were Anglo-Saxon by way of what we call primogeniture of birthright. All right, let's continue.
Otis further explained about the civil and political rights of the British colonists by stating, quote, that the colonists, black and white, born here, are free-born British subjects and entitled to all the essential civil rights of such as a truth not only manifest from the provincial charters, from the principles of the common law and the acts of parliament, but from the British Constitution, which was reestablished at the Revolution with a professed design to lecture the liberties of all the subjects to all generations. Again, this was published in 1764 before the Declaration of Independence by one of the colony's most influential members, who was himself influenced by and drew from the ideas of the 17th century political theorist John Locke. Y'all gotta look at John Locke. It's important to point out, even though it's generally accepted that the founding declaration didn't apply to black men, the instrument doesn't mention race or color anywhere in its text. There is no special regard for white men, no exclusion of black men, nor does it mention slavery, in spite of the fact that some were slave owners and very much race conscious. The next was a two-part question. And I asked, was slavery legal, or was it an unconstitutional institution that was tolerated via a series of compromises between the original northern and southern states? And if it was unconstitutional, was slavery in contradiction to and in violation of the constitutional laws of England, the founding declaration, and a violation of the writ of habeas corpus? The truth is, slavery was an unconstitutional institution, which was tolerated, and there were compromises that stand as evidence of government's toleration. For example, the Three-Fifths Compromise, Fugitive Slave Act of 1793, Missouri Compromise of 1820 and 21, the gag rule in Congress when the abolitionists began submitting petitions about ending slavery to Congress. Pro-slavery representatives passed a quote-unquote gag rule.
Stop. Okay. You know, he spoke about British legislation, laws from Parliament. Freeman cannot use those laws. All right? You can't use those laws. Those were those reserved for those who were subjects of the crown. Freemen are not subjects of the crown. Freemen are not subjects of anybody because they expatriated from their nation by identifying with a term that associated with their emancipation. It had nothing to do with a legal status, denoting that those who come from a nation or by a nation, people who do that nation have some type of inheritance to what we know as a right of birth. All right? Nothing whatsoever denoting to a right of birth. All right? Let's continue.
Prevented these petitions from being discussed. Then you had the Compromise of 1850. You had the Kansas-Nebraska Act of 1854 and the Crittenden Compromise of 1860. With regard to slavery's unconstitutionality, before Lysander Spooner's 1860 publication, called The Unconstitutionality of Slavery, Volume 1, a Philadelphian published a book in 1819 entitled Free Remarks of the Spirit of the Federal Constitution, the Practice of the Federal Government, and the Obligations of the Union respecting the exclusion of slavery from the territories of the states. Now, in this book, the author states, quote, the utmost that can be said of the Constitution on this point is that it tolerates slavery in the old states. Slavery could find no shelter under the Constitution.
That's a straight lie. If Section 9, Article 1 states that slavery is regulated by the legislation, what we call allowance of migration, as established by the Dred Scott case. So the Constitution is a slave document. It has nothing to do with freedom other than those that they had the right to do that was they considered free. And that was only for the free white person, not you.
And two, Lord Mansfield's 1772 ruling in Somerset is evidence of the acknowledgement that Somerset was in fact a man protected by law and not some individual who faced the burden of a piece of property due to his ancestry and phenotype. Now, the next question I said needed to be answered is, what was Lincoln quoted as saying in regards to freedmen and their involvement in the Civil War?
Let's go back a little further.
Now, the National Father of Revolution, while draw from bondage and refer them to the decision of his rights, end quote. The author then references the 1772 case of Somerset versus Stewart, in which an enslaved man won his freedom in court after his enslavement took him to England, and slavery was deemed inconsistent with the laws of England. The author states this, quote, the doctrine laid down by Lord Mansfield in the case of the Negro Somerset in England would be as applicable and ought to be as efficacious right here, end quote. What the author is making reference to then is the fact that slavery was a violation of the principle of habeas corpus. I'm going to read some very important points about the writ of habeas corpus from Spooner's Unconstitutionality of Slavery. When speaking of early Anglo arrivals, he stated, quote, when our ancestors came to this country, they brought with them the common law of England, including the writ of habeas corpus, the essential principle of which is to deny the right of property of man, the trial by jury.
Stop. Okay. He said when they first came here into Anglo-America that they brought all over here the right of habeas corpus. The right of habeas corpus is a writ, which is a right from a royal prerogative of the king. It's not their right. That right, if it was, then those to those who were subjects of the crown and lieu of petitioner right, as set forth in United States versus O'Keefe. All right, United States versus O'Keefe, petitioner right is a right going back to who? Edward the First, and not this guy Lynn Sanders Spooner. But you're gonna take it by word of mouth that they are the rightful influences in regards to the right to call forth the body in lieu of what we call a writ of habeas corpus, which is not a petitioner right if you're a slave, because we know the Fifth Amendment deals with the right against self-incrimination, which he's about to talk about. All right, but that right was not incorporated in the 14th Amendment at all. He's about to put his foot in his mouth again. Let's see.
And the other great principles of liberty which prevail in England and which have made it impossible that England's soil should be trod by the foot of a slave. These principles were incorporated into all the charters granted to the colonies. The general provisions of those charters were that the laws of the colonies should, quote, not be repugnant or contrary, but as nearly as circumstances would allow, conformable to the laws, statutes, and rights of our kingdom of England. Those charters were the fundamental constitutions of the colonies, with some immaterial exceptions up to the time of the Revolution. as much so as our national and state constitutions are now the fundamental laws of our governments. The authority of these charters during their continuance and the general authority of the common law prior to the Revolution have been recognized by the Supreme Court of the United States. No one of all these charters contained the least information that slavery had or could have any legal existence under. Slavery was therefore as much unconstitutional in the colonies as it was in England. It was decided by the Court of King's Bench in England, Lord Mansfield being Chief Justice, before our revolution. And while
Stop. How are you using these judicial decisions from the King's Bench? How are you using that as your protection at law? All right, because we know Dred Scott said that they had the same rights, the colonists wanted the same rights as the subjects of the Kingdom of England in this realm. All right, so that means that there was subjects in England in this realm when the colonists were enslaving so-called black people. Right? There were black people being enslaved at the same time. Colonists was over here claiming the rights as subjects of England. And we see one of those subjects of England was Dred Scott. Because look at this man's position at the time he was in regards to understanding who he was and his paternal ancestors. And he was telling them, you're not the Anglo-Saxon. Let's hear it out of his mouth. Don't believe me. Frederick Douglass lecture from 26 January 1849 included references to his slaves as Saxon metaphors. During the first speech, the audience was reminded that once the Anglo-Saxon race in England was subject to Norman conquerors, though they now claim superiority to all others and the rights to the plunder and enslave them all. During the second occasion, when he reminded his Anglo-Saxon hearers that the proud Normans once trod upon the necks of their ancestors, the Saxon slave, it was clear that the mental power of the fugitive slave held sway over several hundred half-emancipated American Republicans. According to this report, Douglass maintained sympathy with the medieval Saxons while asking 19th century American Saxons to reconsider their implications of their identification with this ancient race. All right? It's what Frederick Douglass said. On the 16th of February, 1849, the North Star republished an article called Ethnology, written by white Northern abolitionist James Russell Lowell, and originally published by Child Anti-Slavery Standard. Lowell wrote, nations like individuals, when they have risen in a social scale, go immediately to the herald office for a coat of arms and a pedigree. We are obliged to content ourselves with vague assertions of our Anglo-Saxon descent, the truth being that the settlers of New England and of those very few can lay any probable claim to such an origin. All right? Douglass made Anglo-Saxon history his property. It belonged to him just as much as anyone else. Contra Lowell's perception of Anglo-Saxonism and Smith's elision over the facts of Anglo-Saxon history. And yet, while Douglass claimed ownership of this history, he still ended this portion of his speech by alluding to the profitable comparison that might be drawn between the historical Anglo-Saxon and Black American slaves. Let's go back up into the forefront. Right here. The North Star, 16 November 1849, we deem it settled point that the destiny of the colored man, as I read again, is bound up with that of the white people of this country. Be the destiny of the latter what it may, does Douglass capitalize on the Anglo-Saxons to show that the true heirs to the Saxon legacy as a conquered people, we know he must know a little bit about Henry VIII to talk about the conquered people, and we know why the conquest took place in 1450. What was it? 1485 by Henry VIII when he took over the House of Lancaster branch from the cadet branch, which is cadet branch of the Plantagenet crown. It says, by invoking medieval English history and challenging white members of its audience to think of themselves as oppressing Normans rather than Anglo-Saxons, Douglas participated in involving history of the Saxons while calling an end to the Anglo-Saxon sense of radical superiority. All right. In this model, Anglo-Saxon legacy of freedom could be more widely accessible. And in American England, Christopher Haynes writes, tapping the transatlantic genealogies that had circulated through his national culture since at least 1850, Douglas assumes his white Northerners and audience to regard themselves as descendants of those Saxon serfs and plumbs that habit of the identification for its further implications. So he's saying that they were the slaves and we were not in the days of the Anglo-Saxons. All right. He said that they were the serfs. All right. We know that Normandy was invaded by William the Conqueror, and William the Conqueror was the bastard. William the Conqueror didn't have any heirs or descendancy as a result of him not giving off any paternal offspring in regards to that promised and deserved male heir. All right, which evolved from what we call agnatic succession. Very important to understand that, Brother Lord Abba. Let's get back to your documentary.
English charters were the fundamental law of the colonies, that the principles of English liberty were so plainly incompatible with slavery that even if the slaveholder from another part of the world brought his slave into England, not only for a temporary purpose, with no intention of remaining, he nevertheless thereby gave the slave his liberty. Previous to this decision, the privilege of bringing slaves into England for temporary purposes and of carrying them away had been long tolerated. This decision was given in the year 1772. And for all I see, it was equally obligatory in this country as in England, and must have freed every slave in this country if the question had been raised here. But the slave did not know his rights and had no one to raise the question for him. The fact that slavery was tolerated in the...
He said the slave did not know his right and did not have anyone to pose the question for him. All right? That's the same position that Frederick Douglass was. He didn't have a clue about genealogy, but he had enough sense to do an in-depth origin of those ruling at that time based off the superiority of that legal status or that legal standing in law. And he knew that was Anglo-Saxon. And he said that he had more of a claim than those claiming to be the Anglo-Saxon, i.e. white Anglo-Saxon Protestant. All right?
The colonies is no evidence of its legality. The writ of habeas corpus necessarily denies the right of property in man. And the Constitution, by declaring without any discrimination of persons that the privilege of this writ shall not be suspended, that is, it shall not be denied to any human being, has declared under the Constitution, there can be no right of property in man. Mr. Christian, one of Blackstone's editors, says that it is this writ that makes slavery impossible in England. It was on this writ that James Somerset was liberated. The writ, in fact, asserts as a great constitutional principle the natural right of personal liberty. And the privilege of the writ is not confined to citizens, but extends to all human beings. And it is probably the only absolute guarantee that our national constitution gives to foreigners and aliens, that they shall not.
Okay, he said extends to all human beings, but at that time, were black people considered human beings? No. They were considered property, chattel, bond or free. You weren't considered a citizen. All right? You weren't considered having rights in regards to the citizenship they deemed for free white person. All right? Very, very important for you to understand that concept. All right? In lieu of those and vested rights that the Constitution gives, because for you, Constitution brings bondage, not liberty. All right?
Not on their arrival to be enslaved by those of our state governments that exhibit such propensities for enslaving their fellow men. For this purpose, it's a perfect guarantee to people who come here from any part of the world. And if it be such a guarantee to foreigners and aliens, is it no guarantee to those born under the Constitution, especially when the Constitution makes no discrimination of persons? Now, there are two important points made here. One is that the writ of habeas corpus guaranteed that no individual had any right to property in man. And two, Lord Mansfield's 1772 ruling in Somerset is evidence of the acknowledgement that Somerset was in fact a man protected by law and not some individual's beast of burden or piece of property due to his ancestry and phenotype.
Okay.
The next question.
All right. We can come to that conclusion with the Dred Scott case, which we're visiting in a second. He ain't showing no precedents to validate Freedman. Yeah, he's talking about Somerset, who was free, but not under the identity in which they're trying to make it believe, which is the remedy for each and every one of us who come up under their auspices. No, that wasn't Somerset's identity. Somerset was free because he was under English protection, because he was on English land. All right, and slavery was abolished in England, the land of Ingle, or the land of the English. All right, Somerset understood that. King Bench validated that because he was subject to the laws of the king and his bench. Why? Because the king bench law was promulgated by the king and parliament, i.e. king and parliament, i.e. the crown.
I said needed to be answered is, what was Lincoln quoted as saying in regards to Freedmen and their involvement in the Civil War? Now, the National Park Service quotes President Lincoln is saying, without the military help of the black freedmen, the war against the South would not happen. There's a reason.
I'm going to give you my number one tip to get over a breakup, and that is going to be going to therapy. Going to therapy helped me so.
Legislation, the push for race-based, they're freedmen, free.
Call was introduced in the House of Representatives June 24, 1890. So the promises and the commitments of Reconstruction were made to the freedmen class, not to the slave class. It was during the Civil War that the government first acknowledged that a compelling interest exists in taking affirmative action for remedial purposes on behalf of the freedmen class was necessary. We can see that with the attempt at the land distribution via Special Field Order 15, issued on January 16, 1865. The 12th of January,
Land acquisition
met with 20 leaders of the freedmen community of Savannah to discuss the question of emancipation.
Stop. We're talking about land acquisition, all right? Land acquisition is the ability to be able to make claims over territory by claiming to be sovereign through what we call prescription of sovereignty. We know Frederick Douglass was a recorder of deeds, right? Recorder of deeds or deed registry is a governing office tasked with maintaining public records and documents, especially recording related to real estate. All right? Ownership that provides persons other than the owner of the property with real rights over that property. That's called prescription. A non-possessory right over property you don't own. That's called an easement. Let's see what this brings. All right. So right over property that you don't own. That was Frederick Douglass' position. All right, because that's what was being done with the estate that belongs to the heirs at that time because of the abolishment of entail estates as established by New Jersey Revised Statute 46:3-15. All estates entail were abolished and now subject to what we call fee and simple, which is a result of common recovery, changing entail estates into defeasible estates. They're not defeasible. All right, you can't prove the chain of title because the chain of title was automatically invested in the crown. You read that under the public trust doctrine. All right, you read that under the public trust doctrine. It's also qualified in the right discovery doctrine. All right, it's also qualified in the Dred Scott case. All right, so let's continue.
Their chosen leader and spokesman was Baptist minister named Garrison Frazier, about 6 or 7, who had been born in Granville, North Carolina, and was a slave until 1857. He had purchased his freedom and his wife's for $1,000 in gold and silver. Garrison Frazier made it clear on behalf of the freed men that, quote, the way we can best take care of ourselves is to have land and to turn it and till it by our own labor, and we can soon maintain ourselves and have something to spare. We want to be placed on land until we are able to buy it, make it our own labor. A noble and honorable man and a member of the human family who stepped up to take his place among the affairs of men. I said all of this to say that even when using the constitutional laws of England and those of America, our families were and are human beings that no other people had the right to claim ownership over.
Okay, so if you're going to make this statement, then you also must include the laws of the Anglo-Saxon. The origin, you must also include the common law of England. You also must include the English church. That's not in your platform. That's not in your university. You're actually taking away, or instead of repairing, you're dissolving. All right? This is supposed to be a reparation movement, not a dissolving movement, to take away that which we had. Because we were registered with the church, a church state, the body of politics, all right, under the crown. If that's what you're talking about, or what crown are you talking about? The Scottish crown? Because they're not the same. You can ask Dred Scott his situation in regards to his connection, because his surname was Scott. All right?
Europeans, and particularly Anglo-American colonists, acted in violation of their own laws and principles. Our ancestors who were enslaved were nobody's beast, burden, or property, but were in fact men, women, and children, and day one citizens of this nation who were stripped of their rights. The fact is, the American freedmen are a special class of persons and members of the human family whose civil and political rights are to be respected as such. So
I agree with you. Those freedmen rights should be respected, right? The right that you were born with should be respected. The laws of your nation should be respected, which is a birthright as a result of your nationality. And freedman is not your nationality. Okay? It's not your nationality.
That pretty much is the end of what it is that I wanted to present. I hope I did not go over the time limit that you guys had established. Family, and y'all can let me know what we're doing.
No, that was excellent. First and foremost, everybody, if you can, hit the applause emoji, and let's give it up for our brother, Professor Ali, the Freeman, a deaf student. He would understand that terminology. That breakdown was absolutely great. And I'm praying that those of you.
It was not great. Not at all. You miss a lot of important information. All right, that we here at the 13th English Church can give you in regards to some type of legal standing. Because the only thing you prove is that you are a person unknown by a name that you created for yourself as Freedman. But having associated yourself with any body of politics here, presently or formerly, at all, based on what he just said. So if the legal argument to qualify a freedman is going to be presented by Lord Abbott in regards to that legal standing of the nationality, which is the birthright, which is the inheritance that was left, which you so-called say you so eloquently speak of, then let's hear it. Because if not, I will have to disqualify you too. All right. So let's see.
That are on this call. I know we deal with a lot of different distractions. I know social media is a major distraction. That's why I got my phone sitting to the side. I'm not touching it because I don't want to be distracted by anything. I want to pay attention to everything that is being said. And we have this conversation all the time, but you know, when you hear the information in succession in the way that Ali just broke it down, powerful. I think that everybody is able to understand what you just presented. And you made a case, brother, that hasn't been made in a long time in this country. We know that in 1899, the Brotherhood of Liberty, they published a book, Justice or Jurisprudence. And in that book, they're giving, in 1899, this group of brothers out of Baltimore, Maryland, are giving the same types of breakdowns that our brother Ali just gave in 1899. This goes to show, particularly for those of us who have never heard of the Brotherhood of Liberty or their book, Justice or Jurisprudence, that we are in fact on the right track. We're on the right track. So, but Ali, was there anything else that you wanted to add for, you know, for our family that's listening in?
No, not really. I hope that it wasn't too much, and that it was something that could be easily digested, because I really want people to walk away with that information. I think it's important, right? I was trying to stress, right? We use the term Freedman very loose, right? But I think one of the main points that we're trying to express is that the use of the term Freedman is, in my estimation, the United States government's acknowledgement of the manhood and the humanity of the people by calling them freed men and freed women. Before that, they were, like a lot of people would suggest, like, they're three bits of, this is the way people were thinking. They're subhuman. They're that unfortunate race, as they've been referred to by yeah.
To use that language, that
Alexander Stevens in his cornerstone speech calls us that unfortunate race, and they call the women negresses and niggerines, and like, I don't know if y'all know about the niggerine, but niggers and niggerine are the two terminologies they use for women, and Negroes and Negras and niggers, and Blackie and Darkie and Sambo,
Come on, man,
and Shine and Pickaninny, right? They use all of these different names, Monkey, right? All of that stuff. And so these are derogatory terms that they gave to the slave class, the bottom caste of society. So when they start talking about the freed men, this is what I really wanted to really just stick the point to. It's like, yeah, freedmen, right, but the man part of it is very important, because they're acknowledging your humanity for the first time, and that's something that we need to hold them to. We don't need to let them revert back to calling us all of these other phony baloney names. We're not descendants of slaves. Those people, if you listen to what they were saying, those people were actually freeborn people that nobody had any rights, and they were being stripped and robbed of their humanity and stripped and robbed of their natural rights, even in accordance with the laws of England. So that's really it.
Yes, indeed. Yes, indeed. So let's get into my presentation. So
Okay. Before you go. So my question is, he of English descent? Because your last name is Lord Abba. If my memory serves me right, you are Moorish American. His name is Ali Bey. He's Moorish American. All right. You weren't born with Lord Abba or Sheikh Wayel. All right. You have an English name or surname. All right. I don't see Frederick Douglass with the last name El Bey or Douglas Bayel. You know what I'm saying? I don't see that. I understand the degree of the name or why it's used, but it has nothing to do with the identity of the status of you being associated with a nation, a nationality, a nation with a country. I don't see that whatsoever in any presentation, presentment, argument, claim, justification, presumption whatsoever from you or anybody on your team. All right? And what I mean any legitimate evidentiary fact to support your claim in regards to the rights that you have as being part of the human family. I could be wrong. So let's see if you present that, because I haven't seen it from Brother Bay.
The first of many, up until we do our first Freedman convention, the ancestors, family life.
Another thing. I love Brother, whatever name he chooses to go by. It's just his arrogance and the fact that he think he know it all gets to me. Because when you try to have an intelligent conversation with his brother in regards to what it is that he's saying, he comes off as if that he's always the narrative. He always want to remain the narrative point in which is the reflective origin of where the story is supposed to come from. And that's just not the case. You have not given any reason to show forth that I have seen to show that your narrative is conclusive whatsoever. But I could be wrong. Let's see.
Like, I got goosebumps right now. But the ancestors were able to look into the future. They would see us. They would see us right now on this call, and they would be proud. And they would think, you know what, I'm good. Y'all do what y'all gotta do, but we can't meet y'all physically right now. Y'all do what y'all gotta do.
Okay, he just said we can't meet the ancestors physically right now, but so how you know you're communicating with them? All right, where's your communication line? All right, how you communicate with your ancestors if you can't communicate them with them right now? Because we communicate with our ancestors. Me and Marcus Garvey is on the same frequency. All right, he was talking this talk back in 1850. He was on the same frequency that we on now in this present day, and he ain't even here. All right, we have caught up to the frequency of Frederick Douglass on the plane or the astral plane or the etheric plane that he's on in the present. All right, and he ain't got to be physical to be able to, for me to communicate with him. Why? Because we all have the ability to move through time and space. You just said you can't do that. So how could you go back into time that you can't fill in that space, that gap, that conclusion, that missing information. Frederick Douglass was able to do that. Why can't you do that? Let's see why.
Our children, our great grandchildren are coming and they're going to mess you all up for what y'all are trying to do to us. And that's what we're doing right now, family. So, I'm glad that you all are here because I really want to get into this thing. Freeman is a legal status by Naheem Wade.
Okay.
So today,
freedom is a legal status by Naeem Bey. All right, that's what he said. Let's go back to Freeman. Freeman or free woman is a formerly enslaved person who has been released from slavery, usually by legal means. That means by way of a legislative enactment. Okay, so that determined your legal status now, which you said. But now, once you're free, what did you have prior to your freedom being taken away from you? What is it that you can restore to the people that they don't have now as a result of that status of them being enslaved, that you can give them now? What is that legacy? What is that story? What is that memory? What is that course? Because we want to go back. We can't have no future without a past. All right? We can't move to fourth dimension without going visiting the first dimension. All right? Where we originated from, under the same time continuum. All right? You're not able to do that on your platform. Why? Because you just said you can't communicate with your ancestors on the astral plane. I mean, on the physical plane. We know physical is an illusion. All right? We're not communicating with Frederick Douglass in the physical. He's deceased. He's gone. But we can communicate with his frequency of the legacy he left based off that record that's been playing and playing and playing and playing. You ain't listening to that record that's been playing and playing and playing, not just to us who are called his descendants, but around the world. In regards to the very essence of what the word freeman means. Because he said, and from bondage to freeman, he obtained that by understanding his Anglo-Saxon fraternity. That's what he said. All right?
Descendants of slaves would not be race-based, correct? Kavanaugh said to Cameron Norris, a lawyer arguing for the end of race-based affirmative action. Norris seemed caught off guard. I think that's incorrect, Justice Kavanaugh, he said. Kavanaugh then noted that Norris had already acknowledged that the post-Civil War benefits that formerly enslaved people received from the federal government were not race-based. Those benefits were based on their status as having been enslaved, not their skin color. What was the status? Their status as having been enslaved, been past sentence. They're free men, free women now.
Okay, he said facts. I don't see no facts up there. I don't see no facts. Where's the case reference? All I see is something that you cut and pasted. Where is the actual case law? To know into European, because Naeem, Lord Albert, Freeman, you got the United States flag, you got the Circle 7 icon, you got a number 7. I mean, you all over the place, bro. You're all over the place. But do the people see that? That's what they should be looking for.
freedmen and freed women now. So we have a new status in the United States of America because this country's European American citizenry who took on the label white decided that they were going to do something repugnant not only to the Constitution of this country, but also repugnant to the laws that built this republic.
Stop. Let's check this out. Let's go back to Oswald versus United States. We just read in regards to the Naturalization Act of 1790 and their intent of the meaning of free white persons. All right. It says right here, manifestly the test afforded to by a mere color of skin of each individual is impractical, as that differs greatly among persons of the same race, even among Anglo-Saxon, ranging by imperceptible gradation from fair blonde to swarthy brunette, the latter being darker than many of the lighter hued persons of the brown or yellow race. Hence, to adopt the color of test alone will result in a confused overlapping of races and gradual merging of one into the other without any practical line of separation. This is the same thing Frederick Douglass said. Let's make sure. Douglass, make sure you see this. Douglass capitalized on the Anglo-Saxonism to show that the true heirs to the Saxon legacy as a conquered people were not only Mexican, as in the examples above, but also black. And Douglass felt black had even more of a claim in the Anglo-Saxon culture and heritage than the Mexicans did, given their common enslavement. For Douglass, black America could understand Anglo-Saxon England as a point of origin. Why is this? It said, we deem it settled. Point that the destiny, i.e., the manifest destiny of the colored man is bound up with that of the white people of this country, be the destiny of the latter what it may. Remember, they have a manifest destiny. Our destiny was already manifested by us existing because the word manifest means what is evident, you see. What is evident, what is plain to see. All right? Douglass capitalized on the Anglo-Saxon to show that the true heirs to the Saxon legacy as the conquered people were not only Mexican, but black people as well. Because the black people or the colored people or the Negro are actually Anglo-Saxon. How do we know that? Because in order to qualify that, you must satisfy the first test, which is genealogy and ethnicity test, which under the Naturalization Act, you didn't have to fit that qualification because which is based off the classification of the color of the skin deemed free white person, not free men. Because the free men at that time were free white person. All right? Where did you fit into that equation, Lord Abbott? Because you were not considered free white person. You or your nationality is Moorish American. The latter being American. They should have said American Moorish. That's what it should have said. So your rights can proceed. You know, you said Moorish American. So that means that you're included with those who are calling themselves American. We know American resulted from America Vespucius going back to the age of discovery. And we know the age of discovery only took place after it was founded by the law of right, or what we call the right of conquest. All right? Let's get there. Enway versus Hassan. Naturalization Act, that's what we read in Oswald versus United States, all dealing with the terminology, free white person or free man, all mean the same. All right? It says, however, this court does not reside in its decision on that ground, but rather upon the grounds that Arabs as a class are not white and therefore not eligible for citizenship. In view of the evident intent of Congress as interpreted by the Supreme Court in the Dean's case, which we'll discuss in a second, the court should be presented with the conviction case before it holds a person of Asiatic stock to be a white person. All right? Apart from the dark skin of Arabs, it is well known that they are part of the Mohammedan world and that a wide gulf separates their culture from that of the predominantly Christian people of Europe. So you're not even European. You're Asiatic, brother Lo Abba, brother Ali Bey. You're considered Asiatic stock. You're not European, so you can't consider to be a free man, as they classify a free man as free white person, as they stated in this case. Frederick Douglass could be classified because he met the first requirement test, contrast to the latter one that has to deal with the color of skin. Because as we read in Oswald versus United States, that process or that determination has flaws in it. All right? It has flaws. Let's see. It said it cannot be expected that as a class it will readily intermarry with our population and be assimilated into our civilization. The small amount of immigration of these people to the United States is in itself evident of that fact. We know immigration or migration under the Dred Scott case is what we call slaves. All right? Slavery. All right? It says the small amount of the immigration of these people to the United States is in itself evident of that fact. Arabia, moreover, is not immediately contiguous to Europe or even to the Mediterranean. It is true that most of the Arabian Peninsula, including Yemen, is outside the zone from which Asiatic immigration to this country is excluded. And the Supreme Court in Dean case pointed out that Congress could not have intended that natives from the excluded zone can become American citizens. However, it does not follow that all those outside the excluded zone are white persons under this act. You better be listening. To summarize the approach which must be followed in deciding whether a particular person applying for citizenship, because legal status denotes to citizenship. All right? Let's see. Legal status. You see a globe, what you in the globe. That means you got to be on that land somewhere. Birthright, nationality, or immigration. Only one of the three could satisfy that. If it's the former two, then that means you have a right to the homeland. All right? If it's of the latter, then you don't have a right to the homeland. All right? These are the questions you should be asking yourself, Lo Abra, and Lo Mbe Ahmad versus Hassan. Why? Because they said it in this case, right? An individual who presents an aberration from the color of skin of the group in which he is a member, such as a light-skinned Chinese or Japanese, or a dark-skinned Anglo-Saxon, as we say and we are, if you want to use the word to describe our complexion, as Oswald versus United States, as they stated that you can't prove a nationality based off the color of skin because we'll all be mingled together, as they stated in what was that case? What Frederick Douglass said in his interpretation of the Anglo-Saxon here in North America. He said, we are bound up with the white man in regards to the misunderstanding of who we were. And this case speaks to it, because if you make your identity to a nation based off the color of skin, then you're going to be led astray, because people have married into the family, tied into the family unlawfully. All right? This was not supposed to be done. So we have to go back to the original test based off how it's supposed to be established, which is the genetic test, genealogy, ethnicity, and this is done on a biological level. All right? No, I'm not talking about going down to your local DNA store and getting a DNA test. I'm talking about that surname. All right, and tracing that surname from time immemorial, taking that mental state back to the origin of that surname and denoting where the origin of the surname derived from, whether it denote to a thing, denote to a place, or whether it denotes to a person. I mean, patronymic names denote to a person. Way, Sheik, Bay, none of that denotes to a patronymic name, brother Lord Abba. Even Lord Abba don't denote to a patronymic name. All right, not at all. It's just a description. Somebody's sitting high, Lord and Abba are taking the lead on something, which you're not doing because you're not taking the lead on the information that I'm presenting on behalf of our children, my subjects, my heirs, my successors. Why? Because I know their state of existence, just like Frederick Douglass knew the state of existence. Why? Because he was on that frequency. All right? We're on the same frequency. Look up the word transduction. Be able to make sense of information that you receive through what they call transduction. All right. An individual who presents the aberration from the color of skin of a group known as the Freeman of university that you so-called in, something you created, does not thereby acquire a different status under the act from other members of its group. So just because you change your name to Freeman, that don't mean you're different from what Novus Radi declared himself to be. If you're saying that he's the pioneer from which you're taking your stance from. If he's Anglo-Saxon, then guess what, brother? You are Anglo-Saxon, not based off the color of skin, not based off the meaning of the word of an action or an act as a result of emancipation, but because that's who you really are. All right? It says here, since a light-skinned Chinese or Japanese or dark-skinned Anglo-Saxon does not thereby acquire a different status under the act from or members of its group. Of course, when an individual applying for citizenship, i.e. legal status, has a skin of different color than is usual for the member of that group from which he claims to come, a strong burden or proof then rests upon him to show by the usual methods of proving genealogy that he is in fact a member of that group. I have in fact proved that I am a member of that group of the Anglo-Saxon group. Why? Because my surname Jefferson, son means descend down from, and Jeffrey means Lord of earth. Frey means Lord, and Geo means earth. All right, so that's the proof. Not only because of the origin of the surname going back to the family crest and coat of arms. Freedman goes back to Germany. All right, which you about to state in status and supported by the case law based off a German case in lieu of how they're using the word freeman. All right, which is totally different from how they're using it in the United States based off those declare themselves freeman as free white person, i.e. Caucasian. All right. It says here, the burden of proof then rests upon him to show by the usual methods of proving genealogy, all right, that he is in fact, which you have now proven, of that group. After the individuals have been traced into his group, the second question which the court must answer, and we are the jury in at this point. No, Abba? Yes, we are the jury, and I am the judge, all right? I'm judging you, and the jury gonna render their decision on my judge of telling you that you have no clue of what it is that you're talking about. All right. After the individual has been traced into his group, the second question which the court must answer is whether, or the jury must answer, is whether the member of that group as a whole, or a white person, or a free person, or free man, as Congress understood the term in 1790, which you have yet to make the equation with when it was first enacted by the statute. In deciding the latter question, the test is not how the group in question will be classified, but ethnologists, which you should be making that determination, who has made a study of racial origins, but rather what group of people then living in 1790 with the characteristics then existing were intended by Congress to be classified as free man, free persons, or free white person. Applying this principle, the court finds that you as a Muslim, I an Asian, I an Arab, in that Arab are not white person within the meaning of that act. Okay? There it is for you. I know I speak fast, but for itself. What else can I go with this? Let's go ahead. United States versus Dane. United States versus Regards, same thing, in regards to the interpretation of who are considered citizens of the Naturalization Act of 1790 and every Naturalization Act that came afterward. All right. In regards to those being classified citizens under the classification of freedmen, of the Freeman Naturalization Act of 1901, if that, I think that was the act you quoted. But it states here, the ill-chosen name Caucasian invented by Blumenbach is an allusion to a South Caucasian skull of special typical proportion, and applied by him to the so-called white races is still current. All right, so that's where the word Caucasian came from. It brings into one race people such as Arabs and Swedes. All right, that includes you, although these are scarcely less different than the Americans and Malays, who are set down as two distinct races. Again, two of the benchmark providers of mankind are the Australians and the Bushmen, neither of whom, however, seem to have a natural place of Blumenbach series. Hence, it seems to require a strong mental effort to sweep into a single category, however elastic, so many different people, Europeans, North Africans, West Asiatics, Iranians, and others, all the way to the Indo-Gangetic plains and uplands, whose complexion presents every shades of color, except yellow from white to the deepest brown or even black. But they are grouped together in a single division because of their essential properties are one, i.e. the color of skin. The substantial uniformity speaks to the eyes that see below the surfaces. We recognize a common racial and stamp in facial expressions, the structure of the hair, probably also the body proportions. In all of which points they agree more with each other than with other main divisions. Even in the case of certain blacks or very dark races, such as the Beja, Somali, and a few other Eastern Hamathites. We are reminded instinctively more of European or Berbers than of Negroes, thanks to their more regular features and brighter expressions. All right? So we know that when you think about the Caucasian race, that was a race created by Blumenbach, and we know that according to what we just read, United States versus Singh, that they're more reminded of what they call European Berbers, if you want to prove about the ethnicity test or genealogy test, which is not the test required for the Naturalization Act here in 1790, which you fall under in regards to your emancipation through the 14th Amendment. Okay? Once they freed you through the 13th Amendment. All right? As you can see, Caucasian. Caucasian race is an obsolete racial classification of humans based on a new disproven theory of biological race. The Caucasian race was historically regarded as a biological taxon depending on which of the historical race classification was being used, usually included ancient and modern populations from all parts of Europe, Western Asia, Central Asia, Southern Asia, North Africa, and the Horn of Africa. All right, there you have it. All right. So let's get back to your proof.
Those being the laws of England, and those being the laws of Rome.
Okay. All right. He said the laws of England. Oh, yeah. I'm sorry.
When you have these woke revolutions, it requires all of us at some point to say, no, not going to do that.
Out. Succeeded slaves. Ali. Love. Identify. And it's in with which the person is invested for love, for what y'all are trying to do to us. And that's what we're doing right now, family. So, I'm glad that you all are here because I really, really want to get into this thing.
Oh, listen to him.
Freeman and the legal status by Naheem Wade.
So today, a benefit to descendants of slaves would not be race-based, correct? Kavanaugh said to Cameron Norris, a lawyer arguing for defending race-based affirmative action. Norris seemed caught off guard. I think that's incorrect, Justice Kavanaugh, he said. Kavanaugh didn't know that Norris had already acknowledged that the post-Civil War benefits that formerly enslaved people received from the federal government were not race-based. Those benefits were based on their status as having been enslaved, not their skin color. What was the status? Their status as having been enslaved. Men, past tense, they're free men, free women now. Thanks. Free men and free women now. So we have a new status in the United States of America because this country's European American citizens, upon the label white, decided that they were going to do something repugnant not only to the Constitution of this country, but also repugnant to the laws that built this republic. Those being the laws of England, and those being the laws of Rome.
Stop.
And this is what I'm going to do.
Okay. Those being the laws of England and those being the laws of Rome. When you look up Freeman, it doesn't say anything about England because the only free man associated with England is those that are mentioned in what they call the Magna Carta. All right. And the Magna Carta deals with those who are on the land that's free. All right. Let's check this out. Bear with me. All right. Everybody see that? Law of the land. The phrase law of the land is a legal term equivalent to the Latin lex terra or legum terrae in the acquisitive case. It refers to all of the laws enforced within a country or a region, including the statutory law and case-made law, i.e. precedents. All right. In the year 1215, this term was used in the Magna Carta, perhaps the most famous clause, the 39th article in the 1215 Charter, clause 29, and the 1297 statute of the Magna Carta says no free man should be taken or imprisoned or be disseized of his freehold or liberties or free customs or be outlawed or exiled or in any way wise destroyed, nor will we not pass upon him nor condemn him, but by lawful judgment of his peers or by the law of the land. You hear that? If you're a free man, all right? Not freedman, free man, all right? So look up freedman. Freedman, the law is only applicable in ancient Rome and Scandinavia and Arabians in Northern Africa. It says nothing whatsoever in England. Nothing whatsoever in Australia. So how are you going to use England, Lord Abba, to justify the protection that you have as a freedman in lieu of your enslavement? Because we were enslaved after we were free. We were actually enslaved from our freedom as free man. Going back to the Magna Carta, 1215. We were then enslaved going back to the War of the Roses. All right, which we're going to see in the case that I'm going to provide for you. All right, but let's just clear this up to see if you know what you're talking about. Whatever. Because you can't use England as your remedy. All right, you got to depend on Rome.
During my presentation. So I want to get into the legal definition of status. Black's Law Dictionary, first edition, 1891. This is important because in order to understand how the laws for freedmen were constructed, you have to understand the legal context, and you have to understand the legal definitions that went into crafting these particular laws. So I want to start with status, being that status is what my presentation is about. Freedman status, to be particular.
We already defined status, legal standing, which deals with birthright, nationality, which denotes to an inheritance from you being a free man, not one being emancipated. If you're emancipated and your status prior to your emancipated was that of a free man, then what was it? That's what you have yet to prove. All right, and you haven't shown any conclusive evidence to support that freedman other than that of ancient Rome. All right, because you can't use England, because freedmen laws don't apply to laws of England, because the only person that denotes to the freedmen of England are those who were descendant of John, who were descendant of Godfrey, which is my family surname, Godfrey, son of Jeffrey. All right? If you don't believe me, let's prove this. Let's go ahead. Gouvernet versus Detamere. Case law for it. Supreme Court, New Jersey. The question presented by this appeal concerns the right of the father. All right, Lord Abba. Abba means father. So I'm questioning on your rights as the father and being Lord of the fathers. All right? In regards to us being freedmen, because freedman, let's just look at it real quick. It's a German name. Freeman is an English name. See that? English and Irish name. Okay, right there. Freeman or freedman. The question presented by this appeal concerns the right of a father in cases involving dispute over a child's surname, but you have yet to use either. You go by the name of Lord Abba. All right. Your mama didn't name you Lord Abba. All right. That was not the name of your grandparents. All right. In lieu of some type of descent or ascendancy. You just made this up and then want other people to follow that? Man, you must have lost your mind. The question presented by the appeals concerns the right of the father in cases involving disputes over a child's surname to insist that the child bear his surname. So they want all those who follow Lord Abba to follow the surname as Freeman and just drop the surname that was given by their mother and father. That's what you're actually saying. And if they don't drop it, what right do they have in lieu of an inheritance associated with their promises and their passed down through generations? So the issue arises in the context of a child born to unmarried parents, because definitely a Freeman is the result of unmarried parents, who was given his mother's name, surname at birth, and you use a woman to justify Freeman. All right? The father having refused to acknowledge the paternity, when his paternity was established by a test performed approximately 7 months later, the father acknowledged paternity and commissioned visitation. Shortly thereafter, the father instituted litigation seeking joint custody, increased visitation, and the change of the child's surname to his name. Why is this the case? Let's see. And once again, you might have something smart to say against this lecture, Lord Abba. You know what I'm saying? That's fine. But a humble man accepts the truth. All right? Reach out to me. Let me know you want to get on the team. You know what I'm saying? You want to stay in your state as a result of the so-called power you so-called say you have. We know power is a result of force, nothing more. All right? And we know power comes from the source. The surname comes from the French word surnom, sur meaning above or beyond, nom from the Latin nomen meaning name. All right? The use of surname is relatively recent historical practice. In the early life of all races, all right, surname was unknown, while given names have been used from most distinct time to identify, distinguish a particular individual from his fellow. From the beginning to the mid part of the Middle Ages, the term name referred to the giving or first name of an individual. The Anglo-Saxon traditions of surnames date back to the Norman conquest. You hear that? This is case law. This is what you need to show as evidence to justify the adoption of the surname Freeman. All right? And it's not even a surname for you. It's just something that you adopt to identify people that you want us to be when there's no history related to these people other than those going back to the creation, before the creation of Freeman, and that is slaves. All right? Anglo-Saxon traditional surnames date back to the Norman conquest. Surnames are said not to have been used in England until the Norman conquest. All right? So that means if they were not used, that means what? We were all family. All right? We were all family. Noble family. Affluent. President Douglas said he was part of that noble family. Paternity. All right? Even though he chose Douglas, he understood the origin of Douglas was a result of his ignorance of the genealogy and the origin of the surname. But now his understanding gave him the status, even though it was not that of an Englishman, based off the origin of the English status as an English person. All right? So Norman introduced a number of non-English given names, such as Douglas. All right? Let's move down further. At the time owing to the paucity of Christian names, probably an estimate of 200 recovers them all. It became customary to add a name to that of baptism, although the growth of population and the development of cities required a means of distinguishing between individuals with identical given names. The Normans also introduced a number of social practices, the imposition of a feudal land system, and the use of primogeniture as a system of inheritance. that likewise spurs the development of surnames. Surnames came from a number of sources, including accidents, caprice, taste, and multitude of other causes. All right? Cause and effect. Additionally, surnames express a kinship were chosen. The Normans brought with them a custom of naming sons after their father. As a convenience to the feudal system, the feudal lord could thus more easily identify sons of the soldiers most loyal to him. However, patronymics, a name derived from that of the father, was neither compelled nor universal. Inquiry into the naming practices of Western societies demonstrates that the names ordinarily express kinship but not necessarily paternity. All right? Why? Because of that status. All right? Patronymic names derived from the maternal line have been employed in several Western cultures, including modern Spain and medieval England, and England at least at the 14th century, to the time of the what we call right of discovery, which is what we're talking about today. All right, let's get back to him.
Person is his legal position or condition. Thus, when we say that the status of a woman after a decree, nisi, for the dissolution of her marriage with her husband has been made, but before it has been made absolute, is that of a married woman, we mean that she has the same legal rights, liabilities, and disabilities as an ordinary married woman. The term is chiefly applied to persons under disability, persons who have some peculiar condition which prevents the general law from applying to them in the same way as it does to ordinary persons. Is this not what we had to deal with in this country while we were free in the North? In the South, we were enslaved. And the laws appear to not apply to us the same exact way. And so this government, because it was built upon the foundation of the Roman Republic, sort of utilized the history of what the Roman Republic did with its freedom.
That's a lie. That's a lie.
I'm going to break that down as we move forward.
The reason why he's saying that because he don't know a clue about England. That's why he's going to Rome, because most of the Rome cannot be validated. There's no evidentiary proof to support any claims based off any rights associated with a freeman of that time. You know what I'm saying? But he don't know enough about English, right? We're not speaking the language of Rome. We're speaking the language of English. You should make a connection to the English connection to the laws governing English based off the legal status of English and not that of Rome. All right?
Certain rights included with certain capacities and incapacities to take rights and incur duties by which persons as subjects of law are variously determined to certain classes. The rights, duties, capacities, or incapacities which determine a given person to any of these classes constitute a condition or status with which the person is invested. When you hear us harping on Freedman's status, there's a reason why. When we're saying that race-based legislation, the push for race-based remedies or race-based criteria are null and void, I want to paint a picture for you as to why. Let's go to the next slide. Because there's a lot that I have to say, but I'm going to try to get through this thing because I have a lot of slides. So, stats. This is Black's Law, 5th edition. And
no case law. He using Black Law Dictionary to justify his stance on the status of a free man. All right? You know, free man is a German word, right? He gonna use a Black Law Dictionary and a German case law to justify the status of a German over in Germany and make it apply over here in the United States, where Germans were not national citizens here. They were immigrants.
Believe, and I think I'll let you jump in and correct me on this. This is around 1972, I think, if I'm not mistaken, in the 1970s.
He's unsure.
The first definition I read from was from Black's Law 50. Excuse me?
1979.
1979. The first definition that I read from was from Black's Laws Dictionary, first edition, 1891. You can see on your screen that it is clearly different from what I previously read. Excuse me, y'all. I'm excited. I just gotta be honest with y'all. I am excited. So if I get a little tongue-tied, status, standing, state or condition. Standing. What is our standing in this society? What is our state
In this
or
society.
condition in this society? The next words read social position. What is our social position in this society? Status. The status of a people is very, very important.
I can answer that.
Sure, go ahead, brother.
Our standing, our state or condition.
He said he can answer that, y'all. Let's see if he can answer that. What is our status?
Our social position in society is that of the formerly enslaved people.
That's right. It's as simple as that. As simple as that. It says the legal relation of individuals to the rest of the community. The rights, duties, capacities, and incapacities which determine a person to a given class, right? We've seen some of this in the previous definition. But the difference is that they gave an example of a married woman who was seeking to dissolve her marriage, call that divorce thing. In that until that dissolution happens, she still has the what? Duties, rights, capacities, and incapacities as a wife, particularly during that time. You know, women had to go through their whole struggle in women's suffrage movement, etc., etc.
That was the status at that time. He don't want to talk about that, though. He knows what he's talking about, but he ain't informing you he knows what he's talking about because he has another agenda. He understands the status of Negroes, blacks, colored Ethiopian, all right, which is the status of the mom or the mother. He knows that, all right? It will still be the same case as Freeman. There's no change in the status as Freeman from the status of that of maternal paternity, which is contrast or opposed to fraternal. Nothing whatsoever.
Which determine a person to a given class. I want you all to stick a pin in that. Which determine a person to a given class. A legal personal relationship, not temporary in its nature, nor terminable at the mere will of the parties. This means that this isn't a status that can be terminated. When the question was asked,
So it's inalienable. That's what he's saying.
The lawyer.
There was a constitutional law professor who, one of the pretendians, I think, asked her about the Freedman status and whether or not it still exists for us. And she said no, because we were made citizens by the 14th Amendment. Which is completely erroneous, right? But anyway, go ahead, I'll let you finish.
That's right. But that's all I need. I can't think of it, it'll come to me. But this isn't a terminable status. Dr. Sandy Garrity said that the freedmen then were no longer freedmen today. Even after we debunked that claim, he still made the tweet. Now, this isn't one of those, this is a workshop. And this is where we are relaying information, so I'm hoping nobody gets into any feelings. But he was wrong because he claimed that freedmen only pertain to those who were men emancipated in 1865. We're going to debunk that claim in this workshop. And I know some of you have followed my Twitter wall and some of the Twitter spaces that we have done, and we show how we debunk this claim. But we're going to get into a little more detail here. And it says, with which third persons in the state are concerned? And it cites a case, Holzer versus Gooch, Reichbahn, Gesellschaft, right? We know Gooch is basically the original name of Germany, Gooch. And there was a case where it spoke to the status of Jews in Germany. And if those contracts, how they were structured based on the status of Jews in Germany were applicable in the United States. See, I'm not going to get that deep. I'll email you all the PowerPoint.
He ain't going to get that deep. You can't go that deep.
At usabof.org, and I'll send you this, and you can look it up for yourselves. And so the United States of America had to make a determination based on contracts and how those contracts were done in Germany with people of a certain status. That's why it says with which third persons and the state are concerned.
Okay, let's look at the word Freeman again. Freeman is a German word. Using German case law to justify what Black Law Dictionary is saying about the definition of freeman relative to status. Relative to status. All right? So his perception of his articulation is apparently wrong. All right? Apparently it's wrong.
Go to the next slide. Black's Law Dictionary, second edition. Now this has the same, this is the same exact definition as the first edition. There's a reason why I want to use 1910, because it's further removed from 1865. 1891, kind of still in that range, right? Because it's the 1800s. But now we're in 1910. And Black's Law Dictionary, second edition says.
Yes, it validates what you say in regards to Freeman, all right? Because the word Freeman is associated with Roman law, okay? You can't associate with English law because in England they had their own definition of who these English people were considered as free people. All right? Totally different.
Free in Roman law, one who was set free from a state of bondage and emancipated slave. The word is used in the same sense in the United States, respecting Negroes who were formerly slaves. And so we see Negro as the racial identifier. But what about the status of those Negroes? It says formerly slave, meaning that they have a new status now. And the definition lets you know it in Roman law.
Okay, they have a new status now. Let's see what Dred Scott says. Let's see what Dred Scott says. This is Dred Scott, y'all. The public law of Europe formally permitted a master to reclaim his bondsman within a limited period. We're talking about Section 3 of Article 4, Fugitive Slave Clause, all right? State legislation created by the Constitution. Public law of Europe formally permitted a master, they talking about Europe, dealing with the word Caucasian, associated with free white person here in North America, all right? We know that according to the courts, as they stated in United States versus Sing Ting and Ray versus Hassan, we have to fit the first qualification test, proven genealogy and ethnicity, which denotes the dark-skinned Anglo-Saxon, which they are reminded more of European Berbers, contrast to those other terminology that they want us to remain associated with. It says the public law of Europe formally permitted a master to claim bondsman within a limited period of time, wherever he could find him. And one of the capillaries of Charlemagne abolishes the rule of prescription. All right, we know prescription is a law dealing with to be able to want to be able to claim his property within the time frame allowed. All right, it says he directs that whoever within the bounds of Italy, either the runaway slave of the king or the church or any other man, should be found by his master. He should be restored without any bar or prescription of years. We know prescription is a result of acquisition of sovereignty. All right. Yet upon provisions that the master be a Frank or German or of any other nation foreign, but if he be a Lombard or a Roman, you're talking about Roman law, he shall acquire or receive his slave by the law which have been established from ancient times among them, without referring from precedents abroad or to any colonial history. For similar instances, the history of the Confederation and Union for evidence to attest the evidence of this ancient law. In 1783, Congress directed General Washington continue his remonstrances to the commander of the British forces respecting the permitting Negroes belonging to citizens of the state to leave New York and to insist upon the continuance of the measure. Check this out. The committee that made the support of this resolution consisted of Hamilton, Madison, and Sedgwick, and the clause in the federal constitution provided for the restoration of a fugitive slave is a recognition of this ancient right and of the principle that a change of places does not affect a change in condition. So please tell me, Brother Lord Apple, where does this new status come in that you're talking about? Because Dred Scott says different. All right?
Set free from the state of bondage, our ancestors, and emancipated slave, our ancestors, who were emancipated with the 13th Amendment in 1865 nationally with the NAC.
Paying your bills on time raises your credit score, right? Wrong. In fact, this is the first of three major
act of Congress that establishes the 13th Amendment to these United States of America. But also, notice here, there are court cases that are cited. Fairfield versus Lawson. You just cite that all the time. And Davenport.
He's lying. He don't cite that all the time.
Into one of these cases, a little left. I threw this in here because it was in the earlier law dictionary. And I don't know, can y'all still see my screen?
Yes, we can see your screen.
It says Wheeler. This is from the first edition. In Hindu law.
He over in Hindu law, trying to justify the term Freeman.
Between two persons who had made a reciprocal testamentary contract. Why did I throw that? Because I wanted people to know that this is a part of international law.
What is a testamentary contract? What is a testamentary contract? A will. All right? Slaves were willed to whoever the grantee was in regards to the conveyance of property. So you ain't say nothing big. You didn't say nothing of real significance because I know better. People, we here at the Third Timothy English Church know better. All right? We understand trust law.
Not a term confined to the United States of America. Matter of fact, let me rephrase that. That freedman is not a status confined to the United States of America. The only confinement is the English usage of what this status relays in all of these, or how this status, is expressed in all of these different languages across the world. And so a wheeler in Hindu law, the relation between a master or patron and his freedman, and the relation between two persons who have made a reciprocal testamentary contract, etc. Right? So I threw that in there to give an example. So now I'm going to go into the law of freedom and bondage in the United States. And this was authored by John Cartman Hurd. These are references that we were citing 10, 11, 12, 13 years ago, fam. And this was published in 1858. Get into it. It says manumission, 1858. Manumission, that is the legal consequence of the master's act and the condition of a libertinus or freed person is in the institutes ascribed to the just gentium. During the earlier centuries of the Roman Empire, three conditions were recognized among the libertini or freedmen, all, however, inferior to that of ingenuus or freeborn. And I may be pronouncing some of these Roman words wrong. But the descendants of a libertinus were not distinguished from other freeborn persons.
Let's stop here. He's just talking. Let's go here. Twining versus State, 1908 case. Well, I can come to my conclusion. I'm going to end on this. Twining versus State, 211 United States, 78, 1908. Everybody turn to 116. It seems to me that the first inquiry on the writ of error should have been whether upon the record before us that which was actually done in the trial court amounted in law to a violation of privileges in regards to the Fifth Amendment, right to not testify against their own self. All right, we know that that case did not apply to 14th Amendment citizens. All right, if the court was not prepared to hold upon the record before it that the privilege of immunity from self-incrimination had been actually violated, then I submit and ought not to have gone further and held to be incompetent for the state, despite the granting of immunity from self-incrimination by the federal constitution, to compel one accused of crime to be a witness against himself. Whether a state is forbidden by the Constitution of the United States to violate the principles of immunity from self-incrimination is a question which is clearly unnecessary to decide now unless what was in fact done at the trial was consistent with the immunity. But although expressly declared that it will not lend any countenance to the truth of the assumption that the proceedings below were in disregard of the maxim nemo titier cipiusum accusare, without saying whether there was in fact a substantial violation of the privilege of the immunity from self-incrimination, the court, for the purpose only of discussion, has entered upon the academic inquiry of whether a state may, without violating the Constitution of the United States, compel one accused of a crime to bear witness against himself, and question a vast moment, one of such transcendent importance that a court ought not to decide it unless the record before it requires that the course to be adopted. It is entirely consistent with the opinion just delivered that the court think that what is complained of as having been done at the trial of the accused was not in law an infringement of the privilege of immunity from self-incrimination. Yet, as stated, the court in its wisdom has forborne to say whether it is judgment that privilege was in fact violated in the state court, but simply for the purpose of discussion has proceeded on the assumption that the privilege was disregarded at a trial. Why do I say this? As a reason why it takes up first the question of the power of the state so far as the federal constitution is concerned to compel the self-incrimination. The court says that if the right here asserted is not a federal right, that is, in the end of the case, it must not go further. So meaning that if you ain't a federal citizen, you don't have no rights, because the rights that the federal citizens have, the state don't have, because we know what the state surrendered to the federal government and their sovereignty through acquisition of sovereignty remain with the states themselves. And we know the state sovereignty and the United States sovereignty are both based off acquisition of sovereignty through prescription of sovereignty of them claiming to be the sovereign of the land, in which they are not. Because we know the sovereign of the land is the crown, and the crown is intel. It would, I submit, have been more appropriately to say that if no ground, whatever existed under the fact disclosed by the record to contend that a federal right has been violated, this court would be without authority to go further and express its opinion on an abstract question related to the powers of the state under the Constitution. Let's get into it. Listen close, Lord Abba. At the time of the adoption of the 14th Amendment, right, which gave you your citizenship, you were enslaved by the 13th Amendment and became a citizen by the 14th Amendment, all right? But you saying that you acquired different status than those who were freed by the 14th Amendment under the misnomer of Freedman, all right? It says here, at the time of the adoption of the 14th Amendment, immunity from self-incrimination was one of the privileges of immunity belongs to a citizen for the reason that the Fifth Amendment, speaking in the name of the people of the United States, had declared in the terms that no person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. The amendment was long ago decided, operated as a restriction on the exercise of power by the United States or by federal tribunals and agencies, but did not impose any restraint upon the state or upon the state tribunal or agency. The original amendments of the Constitution had their origin, as all know, in the belief of the many patriotic statesmen in the states then composing the Union, that under the Constitution as originally submitted to the people for adoption or rejection, the national government might disregard the fundamental principles of Anglo-American liberty for the maintenance of which our fathers took up arms against the mother country. Did y'all hear that? I'll read this again. The original amendments of the Constitution had their origin, as all know, you should know this as well, Lord Abba, and the belief that many patriotic statesmen in the states then composing of the Union, you're the latter, under the Constitution as originally submitted to the people, what people is in question, for the adoption or rejection, the national government might disregard the fundamental, you hear that? The national government might disregard the fundamental principles of the Anglo-America. You hear that? Anglo-American liberty, for the maintenance of which our fathers took up arms against the mother country. What, let me inquire, must then have been regarded as the principles that were fundamental in the liberty of the citizen? Question mark. Every student of English history will agree that long before the adoption of the Constitution of the United States, certain principles affecting the life, liberty of the subject, including the right to not self-incriminate yourself, along with life, liberty, and pursuit of happiness, as well as protection of that property, it said affecting life, liberty, and the subject have become firmly established in the jurisprudence of England, and were deemed vital to the safety of freemen. There go that word again, Lord Abba. There go that word again. For the deemed vital and safety of freemen, and that among those principles was the one that no person accused of a crime be compelled to be witness against himself. It is true that at one time in England, the practice of questioning the prisoner was enforced in the Star Chamber proceedings. You know what that is? You know what the Star Chamber is, Lord Albert? No, you don't. But we have the authority of Sir James Fitzjames Stephen in the history of the criminal law of England for saying that soon after the Revolution of 1688, the practice of questioning the prisoners died out. Volume 1, page 440. The liberties of the English people had then been placed on a firmer foundation. It didn't say freedmen. It said the English people who were freemen. All right? Then being placed on a firmer foundation, personal liberties was thenceforward jealously guarded. All right? Personal liberties was thenceforward jealously guarded. Certain is that when the present government of the United States was established, it was the belief of all liberty-loving men in America that real, genuine freedom could not exist in any country that recognized the power of a government to compel persons accused of a crime to be witness against themselves, such as those subject to the 14th Amendment. And it's not too much to say that the wise men who laid the foundation of our constitutional government would have stood against at the suggestion that immunity from self-incrimination was not among the essential fundamental principles of English law. An able writer of English American constitutional law has recently well said, when the first Constitution Congress of 1774 claimed, you hear that, to be entitled to the benefits not only of the common law of England, but of such other English statutes as existed at the time of the colonization, in which they have been experienced found to be applicable to their several local and other circumstances. They simply declared the basic principles of English law that English subjects going to a new and uninhabited country carrying with them as their birthright. The laws of England existed within the colonization takes place. English law, public and private, continued in force in all states that became sovereign in 1776. Each state declaring for itself the date from which it would recognize it. Telling the science of jurisprudence 436 to 437, it is undisputedly established that despite differences in the forms of government, the people in the colonies were a unit as to certain leading principles, among which was the principles that the people were entitled to enjoy the rights and privileges of British-born subjects and the benefits of the common laws of England. And that, to the used words of Continental Congress of 1774, by emigration to the colony, the people by no means forfeited, surrendered, or lost any of those rights, but that they were then and their descendants are now entitled to the exercise and enjoyment of them as their local and other circumstances enable them to exercise and enjoy. Check this out. Can there be any doubt that at the opening of the War of Independence, the people of the colonies claimed as one of their birthrights and privileges of immunity from self-incrimination? The question can be answered in but one way. If at the beginning of the Revolutionary War, any lawyer had claimed that once accused of crime could lawfully be compelled to testify against himself, he would have been laughed at by his brethren of the bar, both in England and America. And according with this universal deal as to the rights of freemen, Virginia and the Convention of May 1776, in advance being observed of the Declaration of Independence, made a declaration drawn entirely by the celebrated George Mason, which set forth certain rights as returning to the people of that state and to their posterity as the basis and foundation of the government. Among those rights, the famous declaration distinctly announced was the right of a person not to be compelled to give evidence against himself. Precisely the same declaration was made in Pennsylvania by its convention assembled at Philadelphia at the 15th of July, 1776. Vermont, by its convention of 1777, said, nor can a man accused of a crime be compelled to give evidence against himself. Maryland in 1776 declared that no man ought to be compelled to give evidence against himself in a court of criminal law. Massachusetts in the Constitution of 1780 provides that no subject should be compelled to accuse or to furnish evidence against himself. The same provision was made by New Hampshire in the Constitution of 1784, and North Carolina in 1776 recognized the privilege of immunity from self-incrimination by declaring in its constitution that a man should not be compelled to give evidence against himself. This explicit declaration in the Constitution of leading colonies before the submission of the national Constitution to the people for adoption or rejection caused patriotic men whose fidelity to American liberty no one doubted to protest that the instrument was defective and that it furnished no express guarantee against the violation by the national government of the personal rights that inherit in liberty. Nothing is made clearer by the history of our country than that of the Constitution would not have been accepted by the requisite number of states, but for the understanding on all sides that it should be promptly amended so as to meet this objection. So when the first Congress met, there was entirely unanimity among statesmen of that day as to the necessity of wisdom of having a national Bill of Rights, which would, beyond all question, secure against federal encroachment of all the rights, privileges, and immunities, which everywhere and by everybody in America were then recognized as fundamental in Anglo-American liberty. Hence, the prompt incorporation into the supreme law of the land of the original amendment by the Fifth Amendment, as already stated, it was expressly declared that no one should be compelled in a criminal case to be witness against himself. Those amendments being adopted by a nation of people no longer feared that the United States or the federal agencies could exert power that was inconsistent with the fundamental rights recognized in those amendments. It is to be observed that the amendments introduced no principles now already familiar to the liberty of loving people. They only put in the form of constitutional sanction as barriers against oppression the principle which the people of the colonies with entire unanimity deemed vital to their safety and freedom. As I come to my closing, the prohibition against depriving citizens of subject of his life, liberty, or property without due process of the law is not new in this constitutional history of England, of the English race. Once again, I repeat, the prohibition against depriving the citizen or subject of his life, liberty, or property without due process of the law is not new in the constitutional history of the English race. It is not new in the constitutional history of this country, and it was not new in the Constitution of the United States when it became part of the 14th Amendment in the year 1866. After observing that the equivalent of the phrase due process of law, according to the Lower Code, is found in the words law of the land, in the Great Charter in connection with the guarantees of the right of the subject against the oppression of the crown, the court said, and a series of amendments to the Constitution of the United States proposed and adopted immediately after the organization of the government, which were dictated by the justice of the states as further limitations upon the power of the federal government and found in the fifth in connection with our guarantees of personal rights in the same character. It states here, it is easy to see that when the great barons of England wrung from King John at the point of the sword the concessions that neither their lives nor their property should be disposed of by the crown, except as provided by the law of the land. They meant by the law of the land the ancient and customary laws of the English people, or the laws enacted by the Parliament, of which those barons was the controlling element. It was not in their minds, therefore, to protect themselves against the enactment of laws, but by the Parliament of England. But when in the year of grace 1866, there is placed in the Constitution of the United States a declaration that no state should deprive any person of their life, liberty, or property without due process of the law. Can a state make anything due process of law, which by its own legislation it chooses to declare such? To affirm this is to hold that the prohibition to the state is of no avail and has no application, but the invasion of private right is effective under the forms of the state legislation. All right. So in that, I'll close out. Right here. The public trust doctrine. This is Johnson versus McIntosh. It says the soil to which the crown originally claimed title, being no longer occupied by its ancient inhabitants, was parceled out according to the will of the sovereign power and taken possession of by persons who claim immediately from the crown or immediately through its grantees or deputies. All right. So the land has been transferred by unlawful conveyance as a result of its shipment to the state under the sovereign acquisition power of the state as a result of interstate. You're not being an heir as the ancient inhabitants. So with that, your king, love you all. Brother Lord Abba, as well as Brother Ali Bey, reach out to us on our platform in regards to broadening your understanding on the flight that President Douglas is trying to get you to understand. If you claim to be following his standard of that which is a prerequisite for the freedom of our people from their bondage we're still subject to, based off them being free, and instead of understanding that they were already free based off the laws that were put in place to sustain their freedom, life, liberty, and property. And with that, we here at the Third Timothy Church of England say peace.